Marshawn Anthony Gordon.
Your Honor, the statewide prosecutor is on virtual.
Oh, is this the one with statewide? Okay.
Yes, Your Honor. Mitchell Cooper is the assistant statewide.
I'm going to get the statewide on here.
Yes, Your Honor.
Welcome to an Econo meeting. You are entering the meeting now.
I need Marshawn Gordon. Just give me, the enumerated sheet.
Good afternoon. Can the court hear me?
Good afternoon. This is Judge Allen, and I can hear you. Who am I speaking to?
Sorry, I'm having difficulty hearing. Let me try switching to my laptop.
Grant theft and scheming to defraud. Can I hold the other sheets? Not the enumerated sheets, just the sheets with the notes, the note sheets, all of them. No, I think this is the right one. No, that's okay. This is the right one. Can you hear me yet, counsel?
Yes, I can. Can the court still hear me?
I can hear you perfectly well. Defense counsel is present as well. And he has announced his presence. Go ahead and announce it again, just in case counsel did not hear your name.
Yes, Your Honor. Amir Ladan on behalf of Marshawn Anthony Gordon, who is the B co-defendant in this matter.
All right. All parties are ready and are present and ready to proceed. As to Marshawn Anthony Gordon, the court has reviewed the file and finds probable cause for count 1, grand theft, third degree, greater than 10,000 or less than 20,000, and count 2, scheming to defraud, greater than 20,000. Mr. Ladan, you want it to be heard?
Yes, Your Honor. Just pragmatically speaking, Mr. Gordon's actually charged as in count 2 of a 7-count information with the co-defendants, if I'm looking at the correct charging document.
I think it's count 2 and count 4.
Yes, Your Honor. In those counts, he's charged with 1 second-degree felony, 1 third-degree felony. Bonds were set at the time the warrant was issued, and I don't really know why they're set so high, Your Honor. He is a resident of the state of Florida, has been in Brevard County for a couple of years, and is actively being supervised by probation. He was called into probation when he arrived. He was arrested as to this warrant. We believe the elements of this case will not cause probation to be violated, and he was told as much by probation. So the only thing that should be holding Mr. Gordon in this matter are these 2 bonds. We'd be asking the court to reduce the bonds to an appropriate case level for the purposes of him being released as to these counts.
Counsel for statewide?
Yes, Your Honor. This is Mitchell Cooper from statewide prosecution, just for the record. At the time the capias was signed, the bonds were set at $100,000 on count 2 and $250,000 on count 4. That is consistent. There are 2 other co-defendants. Co-defendant A, Mr. John McClure, has counts 1, 3, 5, 6, and 7, and they were set at $100,000 each count, except for his scheme to defraud count, which was set at $250,000. And co-defendant C on counts 5 and 6 were set at $100,000 each. Mr. Gordon's, all of those bonds remained as set by the judge who reviewed the 50-some-odd page affidavit and signed the capias. Those bonds remained the exact same as that reviewing judge set them. There were some other special conditions that were set, including that the defendant must establish the non-involvement or non-derivative from criminal activity before they're used for release, that he surrender his passport, not travel outside of Orange County, have no contact with co-defendants or witnesses, not conduct business with the retailers involved in this case, specifically Dick's Sporting Goods, Bass Pro Shops, Academy Sports, Target, Walmart, or BJ's, and possess no firearms or weapons. Your Honor, the defendant does have a criminal history relating to theft and organized fraud. He has a Brevard County retail theft less than 100, a Brevard County organized fraud less than $20,000, 2 paraphernalias, no valid driver's license, marijuana less than 20 grams, and also an Indian River County first-degree petty theft. Your Honor, those bonds were appropriate for the co-defendants, and that's why they were remained the same. They were stayed, as well as all of those special conditions. Nothing has changed from the time this capias was signed and approved by Judge Bleckman and this morning. So if they were appropriate for the co-defendants and they were appropriate at the time the capias were served, absolutely nothing has changed between then and now, and I believe that all the conditions should be stayed as well.
Mr. Ladon, anything further?
Yes, Your Honor. The co-defendants, at least one of them, isn't a resident of the state of Florida, so I don't know that we're comparing apples to apples when we speak about the appropriateness of the bonds between the co-defendants. But more appropriately, Judge, my client's involvement is lesser than the co-defendants. The accusations allege that he went in and stole items from different retailers that were then subsequently pawned or disposed of through another co-defendant. So we're talking about glorified theft charges here, one of which is charged as a second-degree felony, one as a third-degree felony. To consider bonds collectively of $350,000 for what really is tantamount to felony theft is a bit egregious, Judge. It's punitive, and it's not really designed to serve a purpose other than to keep the defendant incarcerated, because there's no potential way that he could ever afford to post those bonds. I've been hired by the family to assist him in this matter. He lives with his brother in Brevard County, so if there was a reduction in the bond, we'd also be asking that a modification be made to allow him to return to his residence in Brevard County, where he's lived for the last 2 years, so that he would be able to work and assist me with his defense while he's out on bond on these matters.
All right, thank you both, gentlemen. Unfortunately, the court is not in a position to grant the motion to reduce this bond. The judge who reviewed this probable cause affidavit, and I want you all to know that I reviewed it very carefully, since I saw that the bonds were significant. I looked at it thoroughly, and I see no reason to change the judge's bond. The judge decided that those were appropriate bonds for a reason, and then so bond will stay at $100,000 on count 1, which is count 2 actually, and $250,000 on count 2, which is count 4 for the defendant. And with the following conditions of bond, the defendant must establish the non-involvement in or non-derivation from criminal or other illicit activity of any proffered funds, real property, or any proposed collateral or bond premium prior to release from incarceration. The defendant must surrender any passport to the clerk of court prior to release. The defendant must not travel outside of Orange County, Florida, unless changed by further order of the court. The defendant must have no contact directly or indirectly with any co-defendants or state witnesses. The defendant is ordered to not conduct any business with the following retailers, directly or indirectly, including Dick's Sporting Goods, Bass Pro Shops, Academy Sports, Target, Walmart, or BJ's Wholesale. And the defendant is ordered to possess no firearms or weapons and surrender any firearms or weapons to law enforcement within 24 hours of release. Were there any other conditions that the statewide prosecutor is requesting?
No, Your Honor, I would just request if you could specifically notate that first condition, that the jail is not to accept an affidavit from a bondsman. There was an order signed by Judge Bleckman saying that it needed to be done after review by the state or an order by the court. The jail has a policy that they work under that says a bondsman can submit an affidavit saying that they have verified it. However, we would request that the court order today can also specifically state there needs to be a court order before they will accept the money or before they'll accept the bond.
Okay, just to be clear, are you indicating the judge requested that, or you're requesting that?
The order states, so the order on the state's motion pursuant to the 903.046 states, the defendant shall not be released from custody upon the posting of a bond until either the funds and their source are produced for state inspection and confirmation of their non-criminal origin, or the court satisfies itself at a hearing in this matter.
All right,
So
I'll
that order-
grant that based on that reading. That was an order signed by the judge?
Yes, Your Honor. Judge Blackman signed that on July 5th.
Okay, pursuant to that language, I will grant your motion and order that the jail not release the defendant based on a bondsman's affidavit. And you're asking that it be presented to the judge or set for a hearing before the judge, counsel?
On co-defendant C, the defense attorney sent me all the documentation, sent me an affidavit, showed me that it came from the family, and I signed the stipulation.
All right.
So we can either do it via hearing or with stipulation.
Okay. The court is ordering that the jail not release the defendant based upon an affidavit of a bondsman regarding the source of funds pursuant to the first condition. And defendant can only be released based upon certification of the source of funding based upon an order of the court. Is that what you're asking for me to order?
Yes, Your Honor, and if the clerks could just write that on the paperwork.
They're writing it.
Thank you very much, Your Honor.
All right, thank you. Thank you, Mr. Ledon.
Your Honor, thank
It's
you for allowing
conformity
us
with
to
the judge's
do
order.
this.
I'm familiar with that, Your Honor, so
Yes.
that's consistent.
And apparently you all could, there's nothing that precludes you and the statewide prosecutor from entering a stipulation.
Understood.
Thank you both. And no, of course, the judge signing a stipulation, signing the order.
Your Honor, would it be possible to ask a favor of Your Honor and
Of course.
send a message to Judge Barber and let her know that I'm just now leaving the
Sure.
IAs? She was expecting me.
Georgie Lane Barber?
Yes, Your Honor.
I'll send it right now.
I do appreciate that. May I be excused?
Yes, you're excused.
Thank you, Your Honor. Have a great afternoon.
Thank you.
Your Honor, that's all I have. May I be excused as well?
Yes, sir, you're excused as well.
Thank you very much. I'm sitting in a Seminole County Courthouse hallway, so thank you for letting us appear virtual.
Oh, it's my pleasure. Thank you. I'm sorry for the delay.
No, I'm still waiting for this case, so it worked out. Thank you, Your Honor.
Okay.
Good afternoon, Your Honor. This is Rafael Barrera, State Certified Court Interpreter. I have been previously sworn.
All right, good afternoon. We're gonna swear in the defendant, Mr. Jimenez Rodriguez.
Thank you, Your Honor. If you allow me just a moment to connect and confirm, please.
Sure.
Your Honor, the interpreter can confirm this defendant is able to hear through the headsets.
All right, let's swear him in.
Yes?
All right, this is Mr. Jimenez Rodriguez. Madam Clerk, okay. Case number 2022 CF 9263 AO. Mr. Jimenez Rodriguez, the court finds probable cause in your case for count 1, sexual battery on a child 12 to 18 years old by a person in familial or custodial authority. The court is ordering the bond to stay at no bond. Count 2, sexual battery on a child 12 to 18 years old by a person in familial or custodial authority. The court is ordering the bond to stay and no bond. Count 3, sexual battery on a child 12 to 18 years old by a person in familial or custodial authority. Bond shall stay set at no bond. Count 4, lewd or lascivious molestation, for which the court will set a bond of $3,500. Count 5, use of a child in a sexual performance, for which the court will set a bond of $1,500. Count 6, lewd or lascivious exhibition, for which the court will set a bond of $500. Conditions of bond are that you have no contact with the victim, no contact with the victim's family, that you have no contact with minor children under the age of 18 years old, that you not return to the victim's home, that you possess no weapons and no firearms and surrender any weapons or firearms to law enforcement within 24 hours of your release. State, do you have any other recommended conditions of bond or conditions of release?
No, Your Honor.
Right. Sir, I have appointed the public defender to represent you in this case. Thank you. Okay, now number 2. The next case is Moses Rueda Leon, case number 2022, CF 8219AO.
Your Honor, the interpreter can confirm this dependent is able to hear through the headsets.
Thank you. Mr. Rueda Leon, in your case, the court finds probable cause for sexual battery on a child 12 to 18 years old by a person in familiar or custodial authority. Count 1, the bond shall stay set at no bond. The court finds probable cause for count 2, sexual battery on a child 12 to 18 years old by a person in familial or custodial authority. Bond shall stay set at no bond. Conditions of release are that you have no contact with the victim, no contact with the victim's family, that you not return to the victim's home, that you have no contact with any minor children under the age of 18, that you possess no weapons and no firearms, and surrender any weapons or any firearms to law enforcement within 24 hours of your release. State, do you request any additional conditions in this case?
No, Your Honor.
Thank you. Okay, sir, I have appointed the public defender to represent you in your case, and you are excused. Mr. Interpreter, that's it for the Spanish cases. Thank you.
Thank you, Your Honor. Have a good afternoon.
You have a good afternoon, too. Now, I see the big numbers. These are the move-ups, 1 through. All right, they're all over the place. Are these in the order of the move-ups? Yes, sir. Okay, all right, sounds like a plan. Yes, James Edward Lawrence. Mr. Lawrence, the court finds probable cause in your case for battery, for which you qualify for pretrial release, and I will order you to participate in pretrial release. Conditions of release are that you possess no weapons and no firearms and surrender any in your possession to law enforcement within 24 hours of release, that you have no contact with the victim, and that you not return to the location where this incident occurred.
Your Honor, I do believe this is roommate. Can he have a one-time?
I will order a one-time visit in the presence of law enforcement to recover any personal items. Yes, the court is ordering pretrial release in this case. No bond. Pretrial release only. Johnny Miller. Johnny Miller's mental health. Does the public defender wish to waive Mr. Miller's presence since he's mental health?
Yes, Your Honor.
All right, the court does find probable cause in this case for trespass, and I am setting a bond of $250. Three. Joshua Forcier. Mr. Forcier, the court, you were picked up for violation of your pretrial release conditions by committing a new law violation on or about July 31st, 2022, and bond is set at $500 in your case.
Your Honor, does Madam Clerk have any indication that Mr. Forcier signed a plea recently on this case?
On the,
On,
on 2022 MM 3922AO?
Yes, Your Honor.
All right, Madam Clerk. Okay. Well, I did not see it when I looked through the file, but we can just have him step to the back and we'll
Case
move
hasn't
on.
even been filed yet. There hasn't been an offer conveyed.
Okay. All right, there may be another case. I mean, I looked through the case as I went through the probable cause. I did not see a plea or a disposition or a sentencing.
Oh,
Your Honor.
this is the case that we saw, I don't remember if it was you or Letitia. He was arrested 7/31 on another case. And this was his out on bond case. So he's now being seen on this case. The clerk site has it as a written plea was filed. However, the case has not been filed by Info or NTA. The case was currently in a return to state status. So there was a written plea filed, however, it hasn't been filed, so he can't plead to anything as there's not currently a case
I
open.
understand. All right, thank you, sir. All right, what number am I on, number 4? Rosa Lee Moore is mental health. Does the public defender, I have appointed the public defender. Do you wish to waive their presence?
Yes, Your Honor.
All right, as to Ms. Moore, her presence is waived, and I do find probable cause for the offense of petty theft, and bond is set at $500.
They will ask for a no return, Your Honor.
Yes, the court will order no return to the location where this incident occurred. And that's number 4. Next, number 5, Jane Doe. All right, Jane Doe refused. Do you wish to waive Jane Doe's presence, or do you need Jane Doe here?
We'd waive the appearance, Your
All
Honor.
right, Jane Doe's presence is waived. The court does find probable cause as to count 1, assault on a law enforcement officer. Bond stays at $250, and count 2, resisting without violence. Bond stays at $100.
Your Honor, she has a name, Krista Sanja Roberto.
All right, we'll add the AKA, also known as Krista. Can you spell it? Sandra Roberto.
CHRISSA.
Thank you. Oh, there you go, you got it. All right, that was number 5. So we're on number 6 now. Garfield and Kenyatto. Okay, a lot of refusals today. Do you wish to waive this person's presence?
Yes, Your Honor.
All right, the court does find probable cause for the offense of grand theft, 3rd degree of a motor vehicle, and bond stays at $3,500. Defendant is ordered to have no contact with the victim and not return to the location where this incident occurred. The out on bond cases, if they have been filed, the court's intention is to revoke bond and set no bond on all counts.
The first one, 21 CF 3134, the Osceola case has been filed.
And that's the 3134 case?
Yes, Your
All
Honor.
right, the court revokes the bond. That's the 2021 CF 3134. All 4, looks like count 2, 1 and 2. The court is revoking a bond and ordering no bond.
The other case, 3135, has also been filed.
And the court revokes the bond as to case number 2021 CF 3135 and orders no bond as to both count 1 and 2. That's number 6, and then I think there was a number 7. Did you need this? You want me to just start handing you these back, like we usually do? Okay, number 7. Matthew Nash. Mr. Nash, in your case, you were picked up for failing to appear on 3 counts. Bond stays at no bond on each of 3 counts.
Your Honor,
Yes, sir.
there's a-
to downtown court.
Mm-hmm.
Those 3 cases, it looks like they revoked ROR, and the second page is the highlighted area.
Order dated 8/9/2002, bond and no bond. Is this a different case than this
Same
case?
case as the one we just saw.
Mm-hmm. 3.
Probably shouldn't have been there for this one, but he was arrested. Side information about him going to field day. Yesterday, I'm sorry.
Revoke ROR. Pretrial release was granted. Capias was issued, bond was set at no bond. Okay. This doesn't make sense. Revoke ROR and grant pretrial release and then set bond at no bond? So what's going on here? What's going on here?
It was handed to me by,
How did he revoke ROR and then order pretrial release and then set bond at zero? I'm unclear. Does the judge want him on pretrial release or not?
Your Honor, I don't believe he would qualify due to the amount of cases he's out on.
Okay.
I believe, and he is also entitled to a bond.
Is someone, who has, did the public defender file a motion on this case and Judge Blackman grant this?
Allow me to check.
Or was this on Judge Blackman's own motion? I mean, should I email Judge Blackman and find out what he meant on this? Or, I'm sorry for interrupting you, Ms. Fleming. You can go ahead and finish what you were saying.
I do see an order from Judge Blackman on 8/9, so yesterday, order granting state's motion to revoke ROR or pretrial release.
Okay, so he issued this capias based on the state's motion.
I believe so, Your Honor.
All right, okay, then that's all clear. It's totally clear now. Then the bond will stay set at no bond based on the capias in this case. So it's a capias. All right?
Your Honor.
Okay,
Sorry, I couldn't.
that's okay. Based on capias, bond is set at no bond based on the capias. I think that I was.
How do I have an FTA when I've been in jail?
I don't know. I'm going to just refer you to your public defender who I've appointed, and they can cross-reference the day that you should have been in court. And if you were in jail when you should have been in court, then the judge was going to have to reverse that order.
I went to the courthouse Monday, but I didn't go inside.
Did you went as an inmate to the jail, the courthouse on Monday? Well, I could email Judge Blackman. Hold on, just let me email him. Madam Clerk, I'm gonna email Judge Blackman. Can the jail confirm that he was in jail on Monday? On the 9th, what's the date of that order? The 9th? The order,
The date of Blackman's order is the 9th.
so that was yesterday, right?
Yes.
Okay.
He has several different cases.
Can we confirm he was actually in jail that day?
He's been in jail since 7/6/22.
Okay. Seven, 6/22.
Yes, Your Honor.
And state, can you confirm that the state's motion was based on a failure to appear?
I see state's motion on 8/8. It was based off of a new law violation.
Okay, when was the new law about, does it have a specific, it's a new law violation?
Yes, Your Honor, from 22 CF 7835.
I mean, a date, sorry, a date. Was it before July 6, 2022?
Yes, Your Honor.
All right, well then, that's that. I'll not bother Judge Blakeman with that. It seems, sir, that the state's motion was not based on failing to appear court, but rather based on a new law violation. And so Judge Blakeman's order is in all likelihood based on that. And I'll just still refer you to your public defender if you feel like there's some discrepancy. Thank you, sir.
Last question.
Thank you, sir. Thank you. Where did I get this from? Oh, okay.
You can have that. Yeah.
All right.
Just a moment to confer, Your Honor, if I may.
That was Nash, right? Nash and then, Wilson.
Thank you, Your Honor.
Ronald Wilson.
You know, Your Honor.
Mr. Wilson, sir, in your case, the court finds probable cause for sexual battery on a child 12 to 17 by a person greater than 18 years of age. Bond will stay set at no bond. Count 2, lewd and lascivious conduct by a person greater than 17 years of age. Bond will stay at 150, and unlawful use of a two-way communication device, bond will stay at 150. As conditions of bond, you are ordered to have no contact whatsoever with the victim or the victim's family. You are ordered to have no contact with minor children under the age of 18. Not return to the location where these incidents occurred. You're ordered to surrender any firearms or weapons in your possession to law enforcement within 24 hours of your release and possess no firearms or weapons as a condition of release. State, do you have any other conditions that you wish the court to impose?
No, Your Honor.
All right, thank you. Thank you, sir. All right, Madam's Clerk, are we now going chronologically? Are we going to go chronologically from now? Oh, but then after the arraignments, are we going to go chronologically? We're going to follow my docket after that? All right. Oh, at least there aren't that many in jail arraignments. Corey Jamal Slaughter. Sir, you're here for an arraignment on a charge of petty theft, retail theft.
Your Honor, state did convey an offer to Mr. Slaughter of an adjudication of guilt, credit time served, no return to CVS at 7665 West Colonial, and restitution in the amount of $20.10 to CVS.
And Your Honor, I did speak with Mr. Slaughter. We went over the plea form. He does wish to resolve no contest, and I sent the plea form, signed plea form up to the bench.
Are you able to stipulate to a factual basis in the case?
For the purposes of the plea, yes, Your Honor.
All right. Mr. Slaughter, is this your signature here at the bottom of this plea form?
Yes, ma'am.
Did you read the plea form in its entirety before you signed it?
Yes, ma'am.
Are you under the influence of any alcohol, drugs, or medication at this time? You understand that by entering your no contest plea, you're giving up all the rights on the front of the plea form?
Yes, ma'am.
Do you understand a conviction on this case will subject you to being deported if you're not a U.S. citizen?
Yes, ma'am.
All right. The court finds there is a sufficient factual basis based on stipulation of counsel. I'm finding you to be alert and intelligent as well, and you are adjudicated guilty. Is 42 days in jail accurate? Is 42 days correct? And you're sentenced to 42 days in jail with credit for 42 days time served. Further, you must pay all mandatory court costs associated with this case, and you must pay restitution in the amount of $20.10 to CVS. Do we have an address for the CVS?
Yes, Your Honor, it's 7665 West Colonial, and I'm going to follow it up with a restitution order.
All right, at 7665 West Colonial, and you are ordered to not return to the CVS at 7665 West Colonial. I am ordering all monies to be paid within 364 days of your release, and I am ordering your release as to this charge. Do you have any questions? On this case, I'm releasing you. Now, if you have other cases pending, then you have to resolve them before you get out of jail. I don't know. I can tell you this case is, you're being released. You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you, sir.
All right, thank you, ma'am. I appreciate it. Thank you, ma'am.
Danelle Daniels. All right, that case will be, the public defender was well, I guess there was a conflict. Regional counsel is on that case.
Yes, Your Honor.
I don't know if I want to roll that case. Yeah, I did reset it from yesterday, didn't I? Yeah, I'm gonna, schedule it for an arraignment / pretrial. Put arraignment / pretrial. No. I still want her to be arraigned. So when the judge looks at it, the judge will see that she's set for a pretrial and an arraignment at the same time, and they will know to arraign her. Or regional counsel will know to waive her arraignment. And then just set it in that division. I wanted you to do it. I want you to do both, because do you have an arraignment date from that judge? Okay, then set it for arraignment / pretrial and use the pretrial date. Madam Clerk, set it for arraignment / pretrial and just use the pretrial date. Yeah. You got it now? Oh, yeah. Yes, ma'am. Okay, thank you so much. I'd like to sign these immediately. And today is the 10th, or is it the 11th? The 10th. You guys got that? We do it all the time downtown. Stacy Leonard Foster. Okay, oh, that was the case. Sorry, that was the one. Yes. Oh, no, it's not. No, this is another one. It's apparently two that have medical issues and also are represented by regional counsel. So this case I will roll for tomorrow. It hasn't been rolled yet. We'll roll it till tomorrow. You said it. You won't be? Okay, we'll just do the same thing. Court file to indicate the defendant is on medical restriction, set for pretrial / arraignment, and notice regional counsel. Now, what's all this? Okay. Michael Louis Acevedo. Reset. 24 hours. Antoine Ali Adams. Antoine, the court finds probable cause in your case for grand theft 3rd degree, of a motor vehicle bond stays at $500, and trespass in the structure or conveyance bond stays at $100. Conditions of bond, you're ordered to have no contact with the victim and not return to the location where the incident occurred. Elena Soleil Alvarado. The court finds probable cause in your case for fleeing and attempting to elude, and bond is set at $3,000. Thank you. Aubrey Lawrence Anderson. The court finds probable cause in your case for providing false ID to a law enforcement official.
Your Honor, state did convey an offer to Mr. Anderson of a withhold credit time served,
How much time served does Mr. Aubrey Anderson have?
2 days.
Madam Clerk, does he have 2 days? Aubrey. That's acceptable to the court if he wants to take it. Does he have 2 days credit?
It was booked in on 8/10/22.
Okay, that's acceptable. Does he wish to accept the state's offer?
I believe so, Your Honor. I spoke with him before court. We went over the plea form. I believe he wishes to resolve no contest. Signing the form now, Your Honor.
Okay.
Thank you.
Mr. Anderson, sir, is this your signature at the bottom of this plea form? Did you read the plea form in its entirety before you signed it?
Yes, ma'am.
Are you under the influence of any alcohol, drugs, or medication that would affect your thinking this afternoon?
No, ma'am.
Do you understand a conviction on this case will subject you to being deported if you're not a U.S. citizen?
Yes, ma'am.
There's a sufficient factual basis. You're alert, you're intelligent. I will withhold adjudication of guilt, order 2 days in jail with credit for 2 days' time served. I'll also order you to pay all mandatory court costs associated with this charge. Monies must be paid within 364 days of your release from incarceration. I am ordering your release as to this charge, sir. You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Do you have any questions?
No, ma'am.
Thank you, you're excused. Yes, I did. I am appointing the public defender on all cases unless I am notified of a reason not to appoint the public defender.
Yes, Your Honor.
Orlando Aviles. Bonded per the jail staff. Jordan Allen Bailey.
Yes, ma'am.
Court finds probable cause in your case for battery on a uniformed security officer. Bond stays at $5,000. Thank you, sir.
Your Honor, state would ask for a no contact and a no return to SeaWorld.
The court is ordering no contact with the victim and no return to SeaWorld. David Leroy Blake.
Ma'am.
All right, Mr. Blake, you have several cases. Court, you were picked up for failure to appear in 3 cases, for which bond will stay set at $1,000 on the first case, $750 on the second case, and $750 on the third case. You also have a new law of dealing in stolen property for which the court finds probable cause and orders a bond of $1,500. Thank you, sir. Brittany Chandler. Refused.
We'll waive the appearance, Your Honor.
All right. As to Brittany Chandler, the defense has waived appearance, and so therefore, I do find probable cause for the charge of grand theft, 3rd degree of a motor vehicle, and bond stays at $3,500. The auto bond case, was that case charged or
Yes, Your
filed?
Honor, it has been
The
filed.
court revokes the bond in that case and orders a bond of $2,000. Calvin Clark.
How you doing?
Mr. Clark, in your case, you were picked up for failure to appear on 4 counts. Bond will stay at $250 on count 1, $2,500 on count 2, $150 on count 3, and $150 on count 4, sir. Thank you, Mr. Clark. Angelique Usman Clemens. Ms. Clemens, the court finds probable cause for count 1 burglary of an unoccupied structure. Bond stays at $3,500. Count 2 grand theft. Bond stays at $500. And count 3 criminal mischief. Bond is set at $150.
Your Honor, statement asks for no return to the Church of Scientology.
The court is ordering that you not return to the Church of Scientology and have no contact with the victims. Jonathan Colon. Mr. Colon, the court finds probable cause in your case for the offense of count 1, resisting an officer. Bond stays at $500. Count 2, petty theft. Bond stays at $100. The court takes no action on out on bond cases. Joshua Davila. Thank you, sir. Joshua Davila. Mr. Davila, the court finds probable cause for count 1, robbery with a firearm. Bond stays at no bond. Count 2, grand theft, 3rd degree. Bond is set at $150. Count 3, aggravated assault with a firearm. Bond is set at $1,500. And you're ordered to have no contact with the victim in this case, not return to the location where this incident occurred.
Your Honor, statement also requests no contact with the co-defendant, Mr. Myrie.
The court is ordering no contact with the co-defendant. The court is ordering that you possess no firearms and no weapons and surrender any firearms or weapons to law enforcement within 24 hours of release. Imani Davis. The court finds probable cause for driving on a suspended license with knowledge, and bond stays at $500. No action on the out on bond case.
Your Honor.
Yes, sir.
There was an offer to resolve the traffic case.
All right. Are we sure that she's not going to be habitualized as a result of that offer? Where's
Your
mine?
Honor, I looked and I did not see any that would habitualize her, nothing else within the past 5 years or adjudications.
All right, that's acceptable then. We can
And I
resolve
did
it.
go over the plea form with her before court as well. about
Okay,
enhancing
if
the
she wants to resolve it, that's fine. How much time served does she have?
Thank you, Judge.
2 days.
Okay.
And the offer was an adjudication credit time served, Your Honor.
All right, thank you. Ms. Davis, is this your signature here at the bottom of this plea form?
Yes, ma'am.
Did you read the plea form, ma'am, before you signed it?
Not all the way.
Okay, we're gonna just let you read it. It's not too difficult to read. Might take you about 3 or 4 minutes, but go ahead and read it.
Tyler.
All right, let me move to the next case. Okay, Brian Dukes. And let her stand back to that wall, and I'll talk to Mr. Dukes. Mr. Dukes, in your case, sir, I do find probable cause for trespass and failing to leave. Bond is, stayed at $500, and battery on an officer or firefighter or an EMT worker, bond stays at $2,500, and resisting an officer with violence, bond is set to $100. You're ordered to have no contact with the victims in this case and not return to the location where this incident occurred as a condition of bond. Malik James Fisher.
Excuse me, can you repeat?
Yes, sir. The bond as to count 1, trespass and failing to leave, is $500. The bond as to count 2, battery on an officer, firefighter, or an EMT worker, bond is $2,500. Count 3, resisting with violence, I reduced the bond to $100. Now, I also ordered you to have no contact with the victims, and I ordered that you not return to the location where this incident occurred.
Is that the entire mall or just the Target?
I'm sorry, what did you ask?
The entire mall or just the Target?
Miss Prosecutor, he wants to know if it's the entire mall or just the Target.
Your Honor, state would ask that it just be the 3343 Daniels Road address, whether that be the Target or the entire mall. I believe it's just the Target.
No return to 3343 Daniels Road. All right.
Considered the Target, correct?
Well, 3343 Daniels Road is what I'm ordering, and I don't know the specific address for the Target versus the mall. You just can't return to 3343 Daniels Road.
I believe that's the Target.
All right, thank you, sir. Malik Fisher.
Oh, Your Honor, may we recall Imani?
No, let me do Malik Fisher first.
Of course, Your Honor.
All right, Mr. All right, he's medical. All right, Mr. Fisher is outside medical, so, I will reschedule this. We'll just roll it to tomorrow in case he's back. Imani Davis.
Yes, Your Honor. After speaking with Ms. Davis, after she was reading through the plea form, she'd like to withdraw her no contest plea and enter a plea of not guilty. I believe she's on her way to getting a valid license as soon as possible.
Absolutely. All right, Ms. Davis, I do find probable cause for the charge of driving on a suspended license with knowledge, and I will order the bond to stay at $500. Thank you, ma'am.
Thank you.
Looks like I am at Corey Nathaniel Fountain. Mr. Fountain, the court finds probable cause in all 6 of your counts. Count 1, trafficking in 10 grams or greater of 3,4 methylene, methamphetamine, MDMA, ecstasy. Bond is set at $50,000. Count 2, possession of cocaine with the intent to sell or delivery. Bond is set at $5,000. Count 3, possession of firearm by a convicted felon. Bond is set at $4,000. Count 4, resisting an officer without violence. Bond is set at $150. Count 5, possession of cannabis less than 20 grams. Bond is set at $150. And count 6, possession of paraphernalia. Bond is set at $100. Thank you, sir.
Your Honor, so we just asked for the condition of no weapons.
The court is ordering a condition that you possess no weapons or firearms and surrender any in your possession to law enforcement within 24 hours of release. Okay. Rodney Gellin.
Yes.
Mr. Gellin, the court finds probable cause for count 1 fleeing and attempting to elude with lights and sirens. Bond stays at $4,000. Bond is set at $4,000. And driving on a license that was suspended as a habitual traffic offender. Bond stays at $2,500.
Thank you.
Thank you.
Your Honor.
Yes.
To Mr. Fountain, he informed me he had counsel, so no need to appoint PD.
Corey Fountain.
Corey Fountain, Your Honor, yes.
All right, the court is not appointing the public defender on Corey Fountain. Yes? He's the one with the 6 counts. Yes, Toga. Nancy Jean Gonzalez. Ms. Gonzalez, ma'am, the court finds probable cause for failure to appear, or you were picked up actually for failure to appear. A violation of probation status hearing. Bond is set at $1,000. Thank you, ma'am.
Thank you.
Okay, that's all on this page. Now I'm going to the next page. I'm on page 3. Dwayne Alonzo Graham. Mr. Graham. Sir, you have 2 cases. The court does find probable cause for no valid driver's license. Bond stays set at $250.
Excuse me, ma'am, may I?
One moment. Are you Mr. Graham?
Yes.
Okay, let me finish, Mr. Graham.
Yes, ma'am.
I find probable cause for possession of cannabis. Bond stays at $500, and resisting an officer without violence. Bond stays at $100. Miss Prosecutor.
Yes,
She
Your Honor.
has an out on bond case for fleeing and attempting to elude, for which the court intends to revoke the bond if that case has been filed on.
It has not yet, Your Honor. He was just arrested 7/26 on that case.
Okay, all right, so no action on either of the out on bonds. I wasn't gonna take any action on the second out on bond case. Sir, now, did you have something that you wanted to say? I did appoint the public defender, and the public defender will need to let me know if if there's something that needs to be said to me.
Yes, ma'am. Thank you.
Thank you, sir. Tiffany Delilah Hall. All right, ma'am, and you have two cases of both of failure to appear, and bond will stay set at $1,000 in the first case and $250 in your second case.
Your Honor, there was an offer to resolve both cases.
Yes, sir.
And I believe it was
Stay convicted and adjudication credit time served on both, Your Honor.
Okay, does she wish to accept?
I believe so. A no contest plea, Your Honor. I went, talked to her before court, went through the plea.
As long as she's read the plea form in its entirety. If she hasn't, she needs to step back to that wall and read the plea form before we take a plea.
I've read it, ma'am.
Okay. If she wants to accept it, adjudication credit for time served as to both cases. That's fine with the court. However, I will need to confirm if the defense counsel is stipulating to a factual basis.
For the purposes of the plea, Your Honor, yes.
All right. Thank you.
The plea form's coming to the bench now. Thank you.
Okay. Ms. Hall, ma'am, is this your signature here at the bottom of this plea form?
Yes, ma'am.
Did you read this plea form in its entirety before you signed it?
Yes, ma'am.
You understand that by entering your plea of no contest, you're giving up the rights on the front of the plea form?
Yes, ma'am.
Are you under the influence of any alcohol or drugs and medicine?
No, ma'am.
Do you understand a conviction on this case will subject you to being deported if you're not a U.S. citizen?
Yes, ma'am.
All right, counsel has stipulated to a factual basis for acceptance of your plea, and I accept that, and I find that you are alert, and I find that you're intelligent. I will adjudicate you guilty. What's the time, sir? 2 days? Is that what it is?
I don't believe so, Your Honor. She may have previous time.
What's the time, sir?
For the first case that I'm looking at,
Mm-hmm.
for 63,
Mhm.
she was never incarcerated on that.
Okay, adjudication of guilt, no further sanctions on that one. And what's the other one?
I'm checking it out, Your Honor.
Oh, she does have 2 days. All right, adjudication of guilt, 63 days with credit for time served, and 2 days. And what's the other one, time served, 1180?
Check right now, Your Honor. Yeah, forgive me, that, because she was arrested yesterday and then being time in today.
Mm-hmm.
2 days.
Okay.
It looks like it is same for that one, Your Honor. It doesn't look like she was arrested on the other.
Still 2 days? Madam Clerk, you confirm that? 2 days both?
Yes, Your Honor.
Also, adjudication of guilt with 2 days in jail and credit for 2 days time served. I am ordering that this sentence run concurrent on both cases. I am ordering your release as to these charges. Further, I am ordering you to pay mandatory court costs associated with both cases, which must be paid within 364 days of your release from incarceration, and I am ordering your release as to this charge, both charges. Do you have any questions?
No, ma'am.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you, ma'am. Look at all this. What is this? What? Oh, for these? Just a lot of stuff up here. I mean, it's very junky and messy, and it's hard to work in this environment. Okay. I straightened it up a little bit. Titus Hayes. Is that who you are? All right, Mr. Hayes, sir. The court does find probable cause for grand theft third degree. Well, state, this is with, of a firearm.
Yes, Your Honor.
And the bond that was, included in PC paperwork was $15,000. I did go through the bond schedule and I found nothing to support that bond either being, and I have no opinion as to should it be higher or should be lower. I just found nothing, zero.
I believe the bond schedule has it to be set, Your Honor. State has no objection to a lower bond.
Yeah, I found absolutely nothing. Okay, it is something that I would probably set around, the 4,000 in keeping with certain other similar charges. Any objection to the court setting a $4,000 bond?
No, Your Honor.
All right, sir, I do find probable cause for the grand theft, third degree of a firearm, and set the bond of $4,000. Order that you possess no firearms and no weapons and surrender any firearms or weapons to law enforcement within 24 hours of release, and that you not return to the location where this incident occurred and have no contact with the victim. Thank you. Adam Thomas Higginbotham. Mr. Higginbotham, the court finds probable cause in your case for a charge of first-degree murder. Bond stays set at no bond in this case. You're ordered to have no contact with the victim's family.
Your Honor, state did file an information. We filed a second-degree murder. However,
Okay.
it's still a PBL, so state would still ask for no bond.
All right, sir, the state has filed an information, including, the charge of second-degree murder. Bond will stay set at zero bond as to that charge, and you're ordered to have no contact with the family of the victim. And you're ordered to possess no weapons and no firearms and surrender any to law enforcement within 24 hours of release. Alfonso Howard. Mr. Howard, in your case, you were picked up for failure to appear, and bond will stay set at $100.
Thank you. Thank you.
Reginald House, counsel, would you like to waive his appearance?
We'll waive, Your Honor, yes.
The court finds probable cause for tampering with the witness, possession of paraphernalia, and resisting an officer without violence. Bond stays set at $100 on each count.
Your Honor, you're lowering count 1 to 100?
No, I didn't lower it. I wrote that it was 100. Oh, that's just my typo. The bond stays at 1,000. That's a typo. Or, I mean, well, a write-o. Not a typo. I didn't type it. I wrote it wrong. My fault. Not perfect. I make mistakes. Okay. Jackie Roy Jackson. Mr. Jackson, sir, the court finds probable cause for possession of fentanyl, possession of cocaine, and possession of methamphetamine as to count 1. Bond stays at 1,000, count 2, 150, count 3, 100. There was an out on bond.
It has been filed, Your Honor.
Okay.
It was a trafficking in cocaine and
That's, the court, is ordering a revocation of the bond as to all counts, which is 3 counts, and bond is set at no bond on each count. Isaac Jefferson. The court finds probable cause in your case for disorderly conduct, and bond is set at $250.
Your Honor, state did convey an offer to Mr. Jefferson of an adjudication, credit time served, no return.
Your
That's
Honor, I spoke with
acceptable.
Mr. Jefferson before court, and I believe he has some defenses to this case. I will be giving him a form with our number on it. And I believe he'll work with our office to resolve this case in a different manner. Would you consider an ROR as the bond?
I would consider it if the state has no objection.
Your Honor, state does object. He has 2 prior failures to appear.
I'll reduce the bond to $100, but I won't do the ROR.
And Your Honor, state would ask for a no return to the links at 455 North Garland.
The court is ordering no return to the links at the address noted. Tashikwe Danielle Johnson. Bonded. Previously bonded per jail staff. Johnny Ulysses Marquez de la Plata. Mr. de la Plata, the court finds probable cause for failure to register as a sex offender, and bond is set at $4,000. State, do you have any other conditions you wish the court to impose?
No, Your Honor.
Thank you. Tabitha Martinson. Yes, ma'am. The court, you were picked up for failure to appear, and your bond stays set at $500, Ms. Martinson.
It stays at what, ma'am?
500.
Your Honor.
Yes.
There was an offer to resolve this case as well.
Yes, sir.
Your Honor, the state conveyed an offer to Ms. Martinson of an adjudication of guilt, credit time served, no return to the Speedway at 13707 West Colonial, and restitution to the Speedway in the amount of $1157.
All right. Does she wish to accept that?
7?
Yep.
If she wishes to accept that, that's acceptable to the court.
Allow me to confirm, Your Honor, just a moment.
Yes. If she needs to read that plea form, just have her stand to the back wall and read it, and we'll just move on to the next case.
I gave her a form before court. I believe she read through it.
All right.
I can ask her right now.
This is Tabitha Martinson. What, I'm out of order or something. Oh, yeah, a bunch of them I forgot to give to you, so you can have those. And you can have that one. That's Martinson right there.
We would just have you stay the bond, Your Honor.
I'm sorry?
We would just have you stay the bond, Your Honor.
All right, the bond stays at $500. Thank you.
We are appointed.
Yes, you are appointed. Okay. Christopher Sean McNeely.
Mental health.
Would you like for me to reschedule that, or do you want to waive his appearance?
We can waive the appearance, Your Honor.
All right, the court's appointing the public defender. The court finds probable cause for count 1, and bond stays at $2,500. Count 2 bond is set to $100.
Your Honor, state would ask for no contact with the victim.
The court's ordering no contact with the victim, no return to the location where the incident occurred. Christopher McNeely. Samuel Melendez. Mr. Melendez, the court finds probable cause in your case, count 1, burglary of an occupied structure. Bond stays at $3,500. Count 2, grand theft. Bond is set to $150, and count 3, criminal mischief. Bond is set to $100. The court's ordering as a condition of bond that you have no contact with the victim, and that you not return to the location where this incident occurred. Thank you very much, Mr. Melendez. Johnny Miller.
Mental health.
All right, Johnny Miller.
We'll waive that appearance, Your Honor.
Actually, didn't we already do that one this afternoon?
Believe so. I think it was under James Miller.
Okay, I have it
up list.
scratched out. That was number 2.
I think we heard that case, Your Honor.
We already heard that case. Timothy Morgan. Bonded per the jail staff. Quran Miri. The court finds probable cause in your case for accessory to a robbery with a firearm. State, I prefer the state to be heard as to a bond on this count.
Your Honor, it is an F2. So state would be asking in the ballpark of 10 to 15 grand.
Defense? Any objection to that?
We would request a $5,000 bond, Your Honor.
All right, based upon the facts of the case, the court's going to order a bond of $10,000. Order that you have no contact with the co-defendant, that you possess no weapons or firearms and surrender any to law enforcement within 24 hours of release, and that you have no contact with the victim. Aisha Pennyfeather, you were picked up for failure to appear. Bond stays set at $1,000 in your case.
Your Honor, State Dick made an offer to Ms. Pennyfeather of an adjudication of guilt, credit time served, and no return to the target at 3343 Daniels Road.
Does she wish to accept that, counsel?
We would just have you stay the bond, Your Honor.
Bond stays at $1,000. Trayvon Shenard Ranking,
Bonded.
bonded per the staff. All right, we're on the last sheet. Daniel Jacob Riderick. Sir, the court finds probable cause in your case for written or recorded threats to conduct a mass shooting or act of terrorism. Bond stays set at $2,500 with the condition that you have no contact with the victim, no contact with the co-defendants, that you not return to the location where this incident occurred, and that you possess no weapons and no firearms as a condition of bond. State, was there a co-defendant? I can't read my own handwriting. I put no contact with the victim and no contact with, looks like co-defendant, but I don't recall there being a co-defendant in this case.
No, Your Honor, I don't believe there was.
No
The
contact
information that
with,
I have.
one moment, State. Let me just, okay, no contact with the victim, co-defendant, or witness. No contact with the victim.
Your Honor, State would request no drugs or alcohol and random UA.
Okay, I'll grant that. Based on the facts of the case, the court is also ordering that you possess and consume no drugs and no alcohol. Of course, there's an exception for drugs that are prescribed by a doctor. And the court is ordering that you submit to, you want random or weekly?
Up to Your Honor, just through PTR.
The court is going to order weekly drug and alcohol monitoring through the pretrial release program.
Your Honor,
Yes, sir.
I'm not sure who the victim is in this case. Can you specify that for me, or the location?
Well, the victim,
Your Honor, I believe the allegations is he was texting messages to his grandparents.
the victims are your grandparents.
Which ones?
The ones that you sent the text messages to.
Okay, and the bond was 2,500, so that would be like 10% then?
The bond is $2,500. And if you are able to post that bond, the bondsman will let you know what percentage you need to pay.
Okay, so I need to like call a bonds person?
Yes,
Okay.
exactly. And you asked about the return, the location. You cannot return to your grandparents' house. Okay. I want him back. Get him back here. Get him back. State, based on the nature of the threat, I also want to order that he not go on any school grounds. All right, sir. Also, based upon the nature of the threat that is alleged to have been made, I'm also ordering that you not go on any school grounds. All right? Okay, thank you. Martha Jean Stevens,
Bonded.
bonded per the jail staff. Emmanuel Bartholomew Strickland. We did ranking, right? And we did Riderick, that was him. Strickland. Strickland? Mr. Strickland?
Yes, Emmanuel Bartholomew Strickland.
All right, Mr. Strickland, sir, the court finds probable cause for possession of an open container, and bond stays at $250 in your case.
I have a bond.
Yes, of $250.
Your Honor, would you consider an ROR as it's an open container?
Any objection, State?
Your Honor, state's only concern is he has a pretty extensive history of open containers. State did convey an offer of an adjudication credit time served. The state would object to an ROR.
Does he wish to accept the state's offer?
I didn't have a chance to speak with him before court. I would have him speak with an attorney before entering a plea on this.
All right, I'll reduce the bond to $100. Nathaniel William Thompson.
Bonded.
Bonded per the staff. DeAndre Walden. In your case, the court finds probable cause for grand theft. And bond stays set at $3,500. There was 2022-6008 AO. The state filed on that case.
It was 6008.
Yes, 6008 AO.
No, Your Honor, state has not yet filed.
The court will take no action on that case, nor will the court take any action on the other out on bond cases. No action.
Okay, the other two were filed.
Kimberly Devon Wilsinski. All right, I was about to sound it out. The court finds probable cause for trespass. Bond stays at $250.
She is out on bond, Your Honor. It is the same location.
I'm sorry, what, okay, all right, I have two people talking to me at one time. Let me just see. Who wants to go first?
I think it's probably the same thing.
Okay, all right, I don't know. Okay. For who? For Wilsinski? Yes, ma'am. I must have. I just forgot to put my little down arrow that reminds me that I reduced it. And it's, State, was that what you were saying too?
No, Your Honor, she's also out on bond for a trespass, and it is at the same location.
I don't have the out on bond, it wasn't attached.
It's
I didn't see it.
22 MM 313 AA.
22 MM
Yes, Your Honor.
31,
313 AA.
okay, and that was filed upon?
She was arrested July 23rd, so approximately 2 weeks ago. It's not yet filed, but it was at the same location.
It was, all right. So you're asking me to just keep the bond at 500? Is that why you're telling me that?
That's fine, Your Honor. I was just bringing it to your attention because it wasn't.
Okay. No, okay. No action on any out on bond, and I did reduce it to $250. I'm ordering you to have no contact with the victim and not return to the location where this incident occurred. Reginald Williams. You were picked up for failure to appear, and your bond will stay set at $500 for that charge. And that's it. There should be no more people coming through that door. May I recess, or is there anything else? Court stands in recess. Sorry, wrong name. Antonio Walker. Mr. Walker, sir, you were picked up for violation of your probation. Condition 5, a new law violation of battery on a law enforcement officer, and another condition 5, resisting an officer with violence on or about August 6, 2022. The court is going to order no bond as to this violation of probation. Thank you, sir. Kenneth Chooks. Mr. Chooks, in your case, you're picked up for violating your probation as follows: violation of condition 5, committing a new law offense of battery dating violence on or about July 31st, 2021, for which bond shall be set at no bond. Thank you, sir. Naquaria Lashadron Jordan Jones. Mr. Jones, you were picked up for violating your probation for the commission of a new law violation and for which bond will remain set at no bond. Todd Stewart,
Yes, ma'am.
in your case, you were picked up for violating your probation, a new law violation, possession of methamphetamine on or about July 11, 2022, for which bond shall remain set at no bond. Reginald Apollon. Are these multiple cases for Mr. Apollon? Oh, this is just, I guess it's just some other stuff. Mr. Apollon, sir, you were picked up for violation of your probation as follows. Condition A, failing to submitting an untruthful report. And condition D, changing of residence without the approval of your probation officer, for which bond will remain set at no bond. Thank you,
Excuse me.
sir. Oh, I'm sorry. Is there a witness here?
Yes. We did tell the probation officer that he had changed the address. We brought it to him.
Hold on one moment. We're going to
Never
swear
changed
you
the
in
address.
for testimony.
Can you raise your right hand, please? Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes, ma'am.
Thank you. Please state your names for the record.
Davier, Emilian.
And is the other person a witness too?
Yes, ma'am.
Can you state your name again?
Mixon Apollon.
What's your last name? Apollon?
Apollon.
Okay, so just like the defendant, okay. So, Mr. Apollon, are you over the age of 18?
Yes, ma'am.
Okay. And Ms. Miller, you wanted to inform the court of something, or I don't know if the state wants to inquire, just let Ms. Miller tell me what she wants me to know.
Your Honor, that's fine.
All right, Ms. Miller, what is it that you want me to know about Mr. Apollon's case?
The address never changed. It was the same address. We had got the proof of all the mails if his address was the same.
Make sure you stay in that microphone, okay?
I'm sorry. The address was the same address. We got proof of him still staying at the same residence that he's still been living at. It never changed.
How long has he lived there? How long?
It's last year of October 2021.
October 2021? And what proof do you believe you have?
Proof of mail of him actually staying there.
I can't hear you. You need to talk.
I got proof of mail, his mail of him, you know what I'm saying, getting addresses of him staying there at the house.
Okay. So the allegation is changing his residence and failing to submit a truthful report. As to both these allegations, a judge reviewed them and ordered no bond. And all I'm going to do in this case is I will inform the judge that you all were here today and that you presented testimony. The public defender that I've appointed on that case is responsible for making sure that this information is brought to the judge's attention in a hearing, and that way the judge can decide whether to reduce the bond, or to grant a bond. Right now, the bond will stay at no bond. However, I did write down what you said. And all I am going to do is email the judge later today and inform them that the witnesses believe they have some information. Both the public defender and the state were sitting right here in court, so they have heard your testimony, and they can also govern themselves accordingly with regard to your testimony. Do you understand, Ms. Apollon, Mr. Apollon and Ms. Miller?
Yeah, I understand a little bit.
Okay.
Say none.
All right.
Excuse me, I can't say none.
Now, you need to talk to the public defender, and they'll let me know if they want you to say anything. Ms. Miller, what's your relationship to the defendant?
Me?
Yes.
I'm his girlfriend, baby mama.
Okay, and Mr. Apollon, what's your relationship?
Older brother. I stay with
Okay,
him.
thank you both. You all are excused. Luis Ernesto Davila Gordon.
Yes, ma'am.
All right, the court in your case finds probable cause for the charge of aggravated stalking with domestic violence. Bond is set in this case at $3,500. Further, I am ordering you to have no contact with the victim, not return to the victim's residence, with the exception of a one-time visit in the presence of law enforcement to recover personal items, and not to possess any weapons or firearms, and surrender any weapons or firearms in your possession to law enforcement within 24 hours of your release.
Okay, ma'am.
Thank you, sir. Rinaldo de Jesus. Mr. De Jesus, in your case, the court finds probable cause for the offense of domestic violence battery. Bond is set at $500. You're ordered to have no contact with the victim, not return to the victim's residence, with the exception of a one-time visit in the presence of law enforcement to recover personal items. Further, you must possess no weapons or firearms and surrender any weapons or firearms in your possession to law enforcement within 24 hours of your release. Charlie Fort. Mr. Ford, the court in your case does find probable cause for count 1, aggravated stalking, domestic violence. Bond in that case is set at $3,500. And count 2, criminal mischief. Bond is set at $500. You are ordered to have no contact with the victim, no contact with the minor child. Further, sir, the court is ordering you to not return to the location where this incident occurred, with the exception of the court's not ordering the one-time visit. Further, you must possess no weapons and no firearms and surrender any weapons or firearms to law enforcement within 24 hours of release. Thank you. There is a case on my list, Luderson Emilcar. What happened to Luderson Emilcar?
It's Creole.
Oh, that's the Creole? Okay, let me just put Creole beside his name. Joshua Huntley. So, Mr. Huntley, the court finds probable cause for battery, domestic violence, for which bond is set at $500. You're ordered to have no contact with the victim. You're ordered to not return to the location where the incident occurred, with the exception of a one-time visit with law enforcement to recover personal items. You must possess no weapons and no firearms as a condition of bond, and you also qualify for pretrial release, so I am actually ordering bond or pretrial release, and ordering that you surrender any firearms or weapons to law enforcement within 24 hours of your release.
Your Honor,
The conditions, the conditions are the same whether you decide to post a bond or participate in PTR. Yes, ma'am?
Your Honor, I was just informing you that DCF was contacted in this case.
In this case, I am also ordering that you comply with any DCF order that may be entered regarding this case. And that is also a condition of bond or release. Zicante Lorraine. In your case,
I live in Maine. How can I don't know if I can get there in 24 hours too, sir. And can they send an officer to pick them up at my house?
so since you live in Maine, I will give you an extension and that you surrender firearms or weapons within 24 hours of traveling back to your home. 24 hours of per defendant, he lives in Maine. Defendant must surrender firearms or weapons within 24 hours of arriving in Maine. Thank you. Thank you, sir. Zicante Lorraine.
Yes, ma'am.
Well, actually, going back to that gentleman who lives in Maine, within 24 hours of release, or or within 24 hours of arriving in Maine. As defendant testifies, he resides in Maine. So just in case he decides not to go to Maine, he still has to surrender him here in Orlando. Does that make sense? Okay. You got it, Madam Clerk? Sure. Sagante Lorraine, the court finds probable cause in your case for battery domestic violence in order that you have no contact with the victim in this case, not return to the location where this incident occurred, with the exception of a one-time visit to recover any personal items. I am ordering a bond of $500. On your out on bond case, the court will take no action.
I'm sorry to interrupt you.
Mhm.
He doesn't qualify for the public defender. He makes $600.
Zacante Lorraine?
Yes, sir.
All right. They, $600 a week, 1,200. In your case, based on your income, you don't qualify for the public defender. Are you going back to work when you get out of jail?
Yes, ma'am.
So I will not appoint the public defender under those circumstances. You'll need to hire your own private counsel. You understand? There's another order that I want to enter in your case, and it is that you possess no weapons and no firearms and surrender any weapons and firearms to law enforcement within 24 hours of your release.
Yes, ma'am.
Thank you. Sir, you are entitled to a lawyer on this case. It's simply because of your income that you don't qualify. If for any reason, once you get out, if you lose your job or they fire you or anything like that happens, then you can reapply for the public defender, and then if you qualify, then you will be appointed to the public defender.
Yes, ma'am.
Thank you. Who's the defendant?
No, you're gonna hit transfer.
Imokar is that's the Creole. Who's the Albanian? Nicola? Theodore Nicola? We need Theodore Nicola for the Albanian interpreter. Ma'am, do you speak English?
Yes.
Are
Yes,
you
Your
here for the
Honor.
Theodore Nicola case?
Yes, Your Honor.
All right. Madam Interpreter, this is Judge Allen.
Hi, Judge. Good morning.
Good morning. Can you tell me your name?
Mimosa Nicola.
My name is Mirlinda, and my ID is 205810.
Okay, is that Miss Londa?
Yes.
All right. We do have both a defendant and a witness in this case. And so the witnesses at this time, we're going to, well, first we're going to swear you in, and then we're going to swear the witness in.
Do you solemnly swear
That's
to
fine.
translate from Albanian to English, from English to Albanian to the best of your ability?
I do.
Okay, now we're gonna swear the,
The witness actually does speak English, but we're going to need you to translate so that the defendant can understand.
Okay.
Yeah, we're going to swear her in.
do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes.
Please state your name for the record.
Mimosa Nicola.
Thank you.
All right, Miss Interpreter, now at this point, I do need you to begin interpreting because even though the defendant, the witness speaks English, the defendant does not.
That's fine.
Very good. All right, Miss Nicola, the lawyers may have questions of you. I don't know if you can speak a little more into that microphone. I barely heard you when you said your name, so we don't have to keep asking you to repeat yourself. Just make sure you can adjust that microphone if you need to. There you go. All right, and I need you to speak clearly into that microphone, okay?
Yes, Your Honor.
Very good.
Good morning, ma'am. Can you please state your relationship to Mr. Theodore Nicola?
I'm his wife.
Mund të më thoni marrëdhënien që keni me zotin Teodor Nikola.
I'm his wife. His wife.
Jam gruaja e tij.
Are you afraid of him?
Yes.
A ke frikë nga ai?
Yes.
Po. Po.
Has anything like this ever happened before?
Yes.
A ka ndodhur ndonjë gjë e tillë më përpara? Po.
Yes.
And do you believe drugs or alcohol were involved in this incident?
A mendon që në këtë incident janë të përfshira drogat ose alkooli?
Alcohol.
Alkooli.
And do you want to have contact with him while this case is pending?
No.
A keni kontakt me të ndërsa kjo çështje është në pritje? Jo.
No.
That's all I have, Your Honor. However, I'd also just bring your attention that DCF was also contacted in this case as well.
Very well. Any questions from the defense?
A keni ndonjë pyetje ju I pandehur?
No, Your Honor.
He said no,
Yeah.
ma'am. All right. Mr. Nicola, the court does find probable cause for false imprisonment, and I am setting a bond of $5,000.
Gjykata e shikon që ti je fajtor dhe unë po e vë atë shumën për lërimin tënd me kush për $5,000.
The court finds probable cause for battery, domestic violence, and I am setting a bond of $500.
Unë mendoj që ka edhe dhunë në familje dhe vendos shumën kushtëzuese $500.
As conditions of bond, you are ordered to have no contact with the victim.
Juve nuk duhet të keni asnjë kontakt me viktimën.
You are ordered to not return to the victim's household.
I urdhëroni që të mos ktheheni te shtëpia e saj.
With the exception of a one-time visit in the presence of law enforcement to recover personal items.
Vetëm një herë mund të shkosh me praninë e oficerëve të ligjit për të marrë sendet e tua personale.
You are ordered to possess no firearms or no weapons as a condition of bond.
Nuk duhet të mbash armë, nuk duhet të mbash armë të ftohta, kjo është kusht I lirimit me kusht.
You are ordered to surrender any firearms or weapons to law enforcement within 24 hours of your release.
Juve duhet të dorëzoni çdo armë, çdo gjë që keni brenda 24 orëve të lirimit tuaj.
You are ordered to possess and consume no alcohol as a condition of your bond.
Juve urdhëroni që të mos përdorni alkool ose ndonjë drogë, kjo është kushti I lirimit tuaj.
The court is ordering you to submit to weekly alcohol monitoring through pretrial release.
Ne jemi të detyruar që të monitorojmë përdorimin e alkoolit gjatë kohës që ju do të jeni I lëruar.
Thank you, sir.
Ju faleminderit.
You just want them monitoring the alcohol testing, correct?
May I?
Yes. To clarify, the defendant does not qualify for pretrial release. The court does require pretrial release to monitor alcohol use.
Neve ti nuk kualifikohesh për lirim para gjyqit, megjithatë gjykata duhet që të monitoroj përdorimin e alkoolit përpara gjyqit.
Your Honor, you just want him to have bond. Because on the paperwork, we did qualify him, but he can have PTR through the drug testing is what you want done along with his bond.
That is exactly correct. So one more clarification. The court is not ordering pretrial release. The court is ordering monitoring of the use of alcohol through pretrial release. The defendant must post a bond.
Pra nuk jepet lërimi para gjyqit, juve duhet të vendosni një bond, domethënë një garanci dorëzani, edhe të bëhet monitorimi i alkoolit përpara se të lëroheni.
Is everybody clear on that now?
A jeni të qartë për këtë?
Nuk jam I qartë për asnjë përdor alkool, jashtë s'jam problem as drog.
Oh, hold on a minute. Let me just, Ms. Fleming, listen, there's a lot of moving parts here. Was DCF involved in this case as well?
Yes, Your Honor, they were called.
One final order, the court must enter. Ms. Interpreter, can you tell the defendant I'm going to enter one final order?
Unë duhet të jap dhe një urdhër tjetër, urdhrin e fundit.
The court is ordering the defendant to have no contact with the minor children and to comply with any DCF order that is entered in this case.
Nuk duhet të keni asnjë komunikim, asnjë lidhje me fëmijët minor tuajt. Before that, he was saying, I don't understand, I don't use drugs, I don't use alcohol.
Okay, the court, it has not made an order regarding any drugs.
Neve nuk kemi dhënë asnjë urdhër lidhur me drogat.
And the witness testified that alcohol was involved in this occurrence.
Dëshmimtarja tha që alkooli ishte I përfshirë në këtë ngjarjen tuaj.
There has been no testimony to refute what the victim has testified to about the involvement of alcohol.
Nuk është dhënë ndonjë dëshmi që ta kundërshtoj atë dhe viktima ka thënë, domethënë që kushti ose shkaku është alkooli.
And the court has concerns about alcohol contributing to violent acts that may harm the victim or the minor child.
Ne kemi shqetësim se përdorimi I alkoolit mundet të lëndoj viktimën ose fëmijën minor.
And that is why the court has ordered the alcohol monitoring through the pretrial release program.
Prandaj ne kemi urdhëruar monitorimin e përdorimit të alkoolit nëpërmjet programeve monitoruese.
The court is concerned about the violence that was involved in this case, and that is why the court is not allowing straight pretrial release.
Ne jemi të shqetësuar lidhur me përdorimin e alkoolit dhe dhunës, prandaj neve e urdhërojmë këtë në lërimin para gjyqit.
Do you have any other questions or concerns, sir?
Thank you, Your Honor. But I'm not
Ke
the
ndonjë
same.
pyetje tjetër?
Jo. Faleminderit, unë. Po më nuk jam I tillë siç e kam përshkruar kryoj ime. Nuk ka rëndësi të pranoj gjitha. Thank you.
Thank you, but I am not like my wife described me.
The public defender has been appointed to represent you in your case.
Ju është caktuar një avokat që do t'ju përfaqësojë në çështjen tënde.
Once you have your consultation with the public defender, you are going to be able to let them know what your defense is and your side of the story.
Nëre kur të takohesh me ata, do t'ju tregosh atyre kush është historia juaj dhe do t'ju tregosh anën tënde të historisë.
Thank you, sir. You are excused.
Ju faleminderit, me kaq e mbarojmë.
Thank you, Miss Interpreter.
You're welcome, Your Honor. Have a nice day.
You have a nice day. Miss Nicola, thank you.
Can I say something, My Honor?
Well, the defendant just left. What did you want to say?
He needs mental evaluation.
Oh, now, I am going to just have the public defender meet with him, and they will make an assessment of what they feel he needs to have done in the case. We don't need to take any more testimony from you since he has now left.
No,
Okay?
that's fine. Thank you, My Honor.
All right, thank you.
Thank you so much.
All right, anything else I need to do? All right. Napoli Luciano Sierra. Sierra. The court finds probable cause in your case for battery, domestic violence. Bond is set at $500. You are ordered to have no contact with the victim and not return to the location where this incident occurred, with the exception of a one-time visit in the presence of law enforcement to recover personal items. You are ordered to possess no weapons and possess no firearms, and surrender any weapons or firearms in your possession to law enforcement within 24 hours of release. As you do also qualify for PTR. In an alternative, you may participate in a PTR, pretrial release program. Whether you can participate in PTR or post bond, the conditions are the same. Thank you. I think that's the stack of finished. Shemar McClendon. Okay, Mr. McClendon, you have two cases here. The court does find probable cause for grand theft third degree of a motor vehicle, and bond stays at $1,000, and probable cause for possession of cannabis. Bond stays at $150. You are to have no contact with the victim and not to return to the location where the victim resides. Further, you were picked up for an on-view violation of probation and for the new law violation, and bond will remain set at no bond on the on-view VOP.
Yeah, I believe there's another one as well.
No, I only have two.
I have an Orange County on-view VOP and then a Volusia on-view VOP.
The Volusia one I'm looking at now, okay? And sir, also for an out-of-county violation of probation, it's also on view, for which the court will order that bond stay set at no bond on that case as well. Thank you, Madam Clerk. Indica Williams. Pedro Rivera.
Yes, ma'am.
You're picked up for violation of your probation for a new law violation for which, of no valid driver's license on or about June 30th, 2022, for which bond will remain set at no bond. Indica Williams. I don't have Pedro or Williams in this. And I got a whole stack of people who I don't even know. All right, Indica Williams. The court finds probable cause in your case for battery, domestic violence. As this witness for the Williams case?
Yes.
Yes. Raise your right hand to be sworn in.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes.
What's your name?
Jeff T. Debuson.
All right, Mr. Debuson, go ahead and speak into that microphone just as clearly as you possibly can. One of the attorneys or both may have questions of you.
Good morning, sir. Can you please state your relationship to Miss Williams?
She's my girlfriend, my mother of my child.
Are you afraid of her?
No, ma'am.
Has anything like this ever occurred before?
No, ma'am.
Do you believe drugs or alcohol were involved in this incident?
No, ma'am.
And do you want to have contact with her while this case is pending?
Yes, ma'am.
That's all I have, Your Honor.
All right, let me just note that I didn't have any probable cause paperwork on this case. Do you have something? I didn't have any.
I can print another one. 1 second, Your Honor.
All right, thank you. Okay. We did Pedro Rivera.
May I approach?
Yes, ma'am. All right, Indica Williams, the court does find probable cause in your case for battery, domestic violence. I forgot to ask, did the public defender have any questions of the witness?
No questions, Your Honor.
Bond will be set at $500 in this case. You do qualify for PTR, so I will also order an alternative that you participate in PTR, bond or PTR. Conditions are the same whether you participate in PTR or post bond. The court is ordering no hostile contact. The court is ordering that you possess no weapons and no firearms and surrender any weapons or firearms to law enforcement within 24 hours of release.
I also believe DCF was contacted, Your Honor.
The court is also ordering that you comply with any DCF order related to this case. Thank you. Thank you, sir. Madam Prosecutor. That was not in the clerk's file for some reason. No, not at all. I looked very, very extensively. Okay, to me, I only have Luderson Emilcar. And then I have all this big, humongous stack. Okay, that's right. Oh, wait a minute. They're coming on the loudspeaker. No hostile contact. Oh, it's busy? Okay. Emilcar? All right, one moment. Ma'am, do you speak English or Creole?
I don't speak English.
You speak English?
No.
Okay. I have it. Like this stack. Here, all that is. That's the. Oh, my paper all down. I just put it up here. Yeah, I put it up there. All right, Stacy Dawn Crum. Can I have the out of county? There you go. Emmanuel Anderson. You know what? I don't really need these because none of those are getting released on. Anderson? I think we have some witnesses. Yes, please.
Everyone raise their right hand, please. Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God? Yes. Please state your names for the record, one at a time.
I am Shonda Anderson, his mother.
Thank you.
I am Nakia Anderson, his older sister.
Thank you.
I'm Ashanti Moore Anderson, his younger sister.
Thank you. All of you are speaking very loudly, and that's good. So whenever you speak, just one at a time, speak into the microphone. State, I don't know if you want to ask any specific questions or just let them tell the court what they want the court to know about this case.
That's fine, Your Honor. I have no questions due to it being an out-of-county warrant.
All right. We're going to go ahead and swear all of you in. We already did? Of course. We'll start with the mother, Ms. Anderson. What do you want me to know about this case?
I want you to know that my son, the out-of-county warrant for the violation of probation was transferred to Orange County, and he completed the probation. And I have here where the Polk County had closed the case, and on October 13, 2019.
2019. All right. And you say you have some documentation of that?
Yes, ma'am.
And can you, Ms. Fleming, can you see that documentation if she holds it up?
Do you want to, you can just pass it over.
All right, Ms. Fleming, would you please evaluate that documentation and tell me what you think it is?
Your Honor, it's titled an order of modification of probation for the case number 19 CF 2284 out of Polk.
The case number again, please?
19 CF 2284 AO. Is that different than
On
the
the
one we
teletype
have?
page? It's the same. 19 CF 2284, okay, that's the case number. What else do you have?
So I have this, it's a modification of probation. All prior conditions carry over, drug evaluation, curfew, court costs, lien. I just believe it's modifying his probation. May I approach?
Yes, ma'am.
I don't believe it's a
Termination. Thank you. So, ma'am, according to the second sentence of this modification, the defendant's probation was converted to a drug offender probation. So the defendant was still on probation. It was just a different level of probation, and that occurred on February 4th, 2020. All other conditions, according to this, carry over. That's the fourth sentence of the modification. So this tells me that the defendant was on probation for drug offender probation. The date of the order is February 4th, 2020, and the amount of the term is 24 months, which is 2 years. So February 4th, 2020 to February 2021 is 1 year. Then February 2022 is 2 years. That might be 24 months. It might be 24 months.
I guess that, Your Honor, it depends on when they filed the violation, if it was before the 2-year mark, or if there's been additional paperwork.
I guess I would need to know that. I do need to know that. I can contact the, so was he being monitored in Orange County or was he being monitored in Polk County?
He was being monitored in Orange County. The probation was transferred to Orange County because he lived in Orange County.
Well, then can't we just, don't we have Orange County probation right here at the jail?
I don't know what.
No, I'm asking the jail staff people.
For county probation, mostly misdemeanors, I believe he's on state probation, so.
Oh, okay.
Yes, Your Honor.
So that office is not going to be here at the jail. It ought to be an easy thing to contact state probation and find out when the alleged violation occurred.
That's what.
You don't have access to files in Polk County, right?
Your Honor, I'm on their clerk of court website right now. I have limited access due to not
Okay.
being an ASA in Polk. However, just 1 second. Okay. So, per the Polk clerk of court, from what I can see, I see a.
And Miss Ms. Fleming, I'm just going, there's another piece of information I want you to have. Even though this modification is dated February 4th, 2020, the judge made it nunc pro tunc to December the 5th, 2019. So that means if he was successfully performing in the probation, it actually would have expired in December 2021.
So I have a violation of probation hearing or arraignment, November of 19. Then he was arrested out of county in Orange County, 11/26 of 2019.
11/26/2019?
11/26/19, yes, Your Honor.
Okay.
He was then arrested out of county in Orange as well, 12/13 of 2019.
Okay.
And then the order for modification of probation, 1/22/20.
Okay.
And 2/6/20.
Okay.
And then there's two to three documents after that on 6/30/20.
Okay, wait a minute. The modification I'm looking at now is February 4th, 2020, nunc pro tunc to December 5th, 2019. So anything after December 2019 or February 20th, February 2020 is what's going to be important. So what do you have after February 2020?
There's three documents dated June 30th of 2020.
Okay,
All of which I am not able to view.
and you say there are three of them?
There's three. One's 3 pages, one's 1 page, and one's 2 pages. So I do not know, I'm not able to access them.
All right, not accessible.
In August of 21, there's a special order of a reassignment to a different section.
August 2021. And all of that is on the Polk County site?
Yes, Your Honor.
Okay.
I'm assuming whatever in those June 2020 documents
Okay.
would clarify, however, I can't see them.
All right. So, ma'am, someone's going to have to contact Polk County because we are unable to evaluate what happened after December 2019. Something happened in June 2020 and August 2021. And we really don't know what it is. The case actually is, it's not going to be easy to get information on this case since we don't have a case in Orange County. There's no file that we can look into our computer system in Orange County. The state did their best to look into another county system, and the information is somewhat lacking because she doesn't have full access. So my best suggestion is to contact the Polk County Probation Office, maybe also the Orange County Probation Office, maybe them as well, but certainly the Polk County Probation Office to find out what was filed after the modification, which you have here. You have the modification, what was filed after that, and which will help you to know what the allegations are for violation of probation. Because I am simply adjudicating the defendant on an out-of-county warrant that was confirmed. So the warrant itself is valid, and that is all I can do. All hope is not lost. I mean, I see you shaking your head like the world is the end, and the world is not ending. All hope is not lost. If, in fact, he had completed his probation, that information will be made available or should be made available to you. If he has not completed his probation and he has violated his probation and just wasn't aware of it, or some kind of way this information was just it passed him by, then you'll find that out as well. And he has been appointed to a lawyer here, the public defender, Do you have something?
Your Honor.
Oh,
At the bottom, that's-
okay. So let me just finish, and then I'm going to tell you about what I was just handed. And so anyone who has a lawyer to represent them, the best thing is to have a lawyer, because the lawyer is trained in information gathering. So the lawyer is going to do their investigation, figure out what happened. You really don't have to do anything, but because you're all the way here today to support your son, and I know that you are kind of an active person and you want to help him. So I'm just telling you that to help him best, you're going to have to know what happened from Polk County's perspective, which we do not have access to, or the access we have is extraordinarily limited. And so the prosecutor gave me all the information she could see. Now, what was just handed to me by jail staff is a document that confirms that Emmanuel Anderson III is an absconder, and his current locations were unknown from his drug offender probation. He was scheduled to terminate from his probation, but he absconded according to this, and he was not able to terminate from his probation. So that could be what happened. And I don't want to speculate further than that.
Okay, they saying he's a absconder. He lived at the same address with me at 926 St. George Street.
Then you're going to be a good witness for him if it comes down to it. Sometimes absconding means leaving the jurisdiction, but sometimes it means not informing probation of any changes that have occurred, and they just don't know where to find you at. But I really don't know, ma'am. I am wholly speculating here.
I understand. I'm just.
It is good to know that you are able to confirm that he was residing with you
Yes, ma'am.
for that extended period of time. That should not hurt him. In fact, it should help him. The public defender is sitting right here listening, and so they're hearing that you could potentially be a very good witness for him. And if your daughters have the same information, meaning they corroborate him, then they can be a good witness as well. So that's pretty much it. I really don't think I need to hear from the other witnesses simply because of the fact that I think we've kind of fleshed through the information that we do have. So your next course of action might be to contact the Polk County Probation Office, as well as the Orange County Probation Office, and tell them that, he has the no bond, but you believe that you can provide them information that will help his case.
Okay.
And then, of course, he has a lawyer, a public defender. And you can also make sure that you inform the public defender and give them copies of any documentation that you may have.
Okay.
Right.
Does it show where the probation was transferred from Polk County to Orange County because he lives in Orange County?
I don't think that information was provided from the state when she and I were talking. But I can assure you that there's no file in Orange County. So since the warrant was from Polk County, he was picked up based on a violation out of Polk County.
Right.
So it could be that there was a courtesy transfer, and he was supposed to reside in Orange County, but report in Polk County, and or report via phone-in or mail-in status. I don't know. So there's just so many variables that are unknown, ma'am. But I can tell you, all hope is not lost. You're a witness for him, and you can provide some background and some details that might help his case. But I don't know for sure how it can help him. I can just tell you that unless you communicate with the people who have the details about what happened and what the allegations are, then I can't. All I can do is confirm to you that I'm ordering no bond based upon a warrant that has been verified. So I'm sorry I can't help you any more than that. So I know you want him home. You're a good mom.
All right, thanks.
Good mom and good sisters. So good luck, sir. Hope it all works out for you. Yeah, I'm ready. Oh, I'm ready. No, I'm not. I'm not contacting nobody on that one. Okay. Luderson Emilcar. Sure. It usually goes over the, oh. I mean, didn't we just do a Albanian interpreter? I mean, what, I mean, it's the same process, right? So it might be the interpreter. Maybe they're doing something. Maybe they're doing more than one hearing at a time and they're putting you on hold. Why don't we just get the person on the line? Just get them on, you had them on the line before. Okay, get them on the line again. All right, well, so the person is actually physically on the line right now? All right, then put her on speakerphone. I don't know. Somebody will show you. Okay, hold on. Turn the volume up as high as you can get it. Is the interpreter able to hear me? This is Judge Allen. Hi.
For Echo, S for Sam. How may I help you?
Well, first of all, I want to be sure you can hear me. This is Judge Allen. Can you hear me?
The interpreter is able to hear you, but is it possible for the phone to be a little bit closer to you?
Well, I can probably make that happen one way or the other for me, but there are other people that I'm not sure if I can make that happen for them. So let me just check, do a sound check. State, can you just introduce yourself and let's see if the interpreter can hear you.
Good morning, Madam Interpreter. This is
Miss Interpreter, we're just doing a sound check right now. Miss Interpreter, let me do a sound check, okay? I want to do a sound check, okay? Miss Interpreter. Miss Interpreter, you are really holding things up here, ma'am. I'm just trying to do a sound check right now. Please, you don't have to interpret a sound check, okay? Just doing a sound check.
good morning, Madam Interpreter. Can you hear me?
This is the interpreter again. It's like you are away from the phone. It's very weak, very feeble.
So, Mr. Public Defender, let's see if she can hear you.
Can you hear me, Madam Interpreter?
Yes, sir.
So now this witness over here, ma'am, I'm going to need you to speak into that microphone. Let's see if that interpreter can hear you. Tell me what your name is, ma'am.
Fedlin Isaac.
She can't hear you, ma'am.
Fedlin Isaac.
The interpreter cannot hear her clearly.
All right, so that's okay, ma'am. We're done with the sound check now. So, Miss Interpreter, this is not going to work because I can fix it where you can hear me better, where you can hear the state, where you can hear the defense, but I cannot fix where you can hear the witness. That's not going to work. So we're going to have to try something else. Hold on.
The only other thing I could think of, Judge, is calling audio text to see why the line is
But it just worked with the Albanian interpreter.
N'a pas obligé font l'autre
Is she actually interpreting?
Nous pas
Are we?
capable d'entendre tout le monde clair avant que nous continuer.
Okay.
Nous pas capable continuer faut faire long.
So we're gonna pass this case. Please remove the defendant. The witness can have a seat. We're gonna pass this case and try to fix the technical difficulty. It's the last case, anyway, and I am continuing with the out-of-county. Shane Lynn Brown.
Shay.
You were picked up on an out-of-county warrant from Seminole County, Florida. Bond will stay set at no bond on both counts. Stacy Dawn Crum. As to Crum, you were picked up on one out-of-county warrant from, it doesn't say what county, from Brevard County, and in this county, in this case, there's a no bond, and bond will stay set at no bond. Your other out-of-county from Lake County, count 1, bond is set at $10,000 and will remain, and count 2, bond will remain at $2,000. Thank you. DeAndre Lavelle Green. Sir, you were picked up on an out-of-county warrant from Sarasota. In your case, bond will stay set at no bond as to both count 1 and count 2. William Pascal. Mr. Pascal, you were picked up on an out-of-county warrant from Osceola. In your case, bond will stay set at no bond. Thank you. Mr. Demetrius Schaaf. You were picked up on an out-of-county warrant from Volusia. Bond will stay at $2,500 in that case. And thank you. Andrew Stevens. Post a bond per jail staff. I think that's the last one. No. Okay, are you guys gonna call the IT people?
Your Honor, state's ready for 33 days if you want to do those while we're waiting.
Yeah, let me turn this crazy volume down. Okay, Michael Jerome Rump, 2022 CF 7957 AO. Does the state?
Granted, notice of non-filing.
All right, the court will grant this motion. Madam Clerk, you need to date these. I have time just to sign them. Tony Ray Ramsey, 22 CF 7977 AO.
Granted, notice
All
of
right,
non-filing.
court will grant that motion per state. Wesley Lamonte Bryant, 2022 CF 5158 AO.
Granted, notice of non-filing.
All right, granted for the state. Eddie James Watkins, 2022 CF 7790 AO.
Granted, notice of non-filing.
Granting that per state. Travis Justin Herndon, 2022 CF 7729 AO.
Granted, notice of non-filing.
All right, and 2022 CF 7743 AO.
Granted, notice of
Okay,
non-filing.
both are granted per state, no file. Yeah. Where's the other order? Oh, my goodness. Well, okay, all right then. Andrew Taki Jackson, 2022 CF 7983 AO.
Your Honor, this one state filed a 40-day extension on.
Okay.
May I
How much
approach-
time is left on the extension?
Well, today would be the 33rd, so it would be an additional 7 days. And I have our motion for good cause. May I approach?
You may.
State's requesting either that you deny it at this time or change the date on the order to the 40th day instead of the 33rd.
No, I'm just going to deny it, granting the state's motion for extension. The defense has leave to refile the motion to release after the 40th day if it's appropriate. Pete Chioka, Richard Pete Chioka. Any objection to the court granting this 3? It's granted per state. Randy Chapel, or Chapel Randy?
22 CF 7976, granted.
All
Notice
right,
on
that's
filing.
granted, state's not filed. Prince Albert Hall, the second,
Granted.
22 CF 8003 AO.
Granted, notice on filing.
Granted, per the state, non-filed. Antonio Maurice White, 22 CF 6950 AO.
Granted, notice on filing.
That's granted due to non-filing. Antonio Maurice White, 22 CF 7979 AO.
Denied and information was filed.
State's filed an information. Per the state, the motion will be denied. Janelle Lamar Jenkins, 2022 CF 7946 AO.
Granted, notice on filing.
Granted per the state, non-filed. And Rupert Lee Pringle, 2022 CF 7828 AO.
Denied and information was filed.
That's denied per the state. 22 CF 6361 AO, Frank Cicini.
Denied and information was filed.
All right, that's denied per the state. Information's been filed. All right. Okay. On this one? Okay. Recalling
Welcome to an Econo meeting. You are entering the meeting now.
Recalling Luderson Emilcar.
You are the only participant.
Okay, well, let's give her a moment to sign in.
What do you mean? It was filed. I think it was e-filed yesterday.
Oh, wait.
He's gonna.
Madam Interpreter, are you available? Madam Interpreter, this is Judge Allen. Anything else for me to sign, y'all? Okay. Oh, okay. Okay. So this is already in the call. I can close it out and call back again. It's better for them to sign on before me. Did Juanita not contact y'all about, 2 pleas that people were trying to do out here this week? Mm.
Welcome to an Econo meeting. You are entering the meeting now.
This is Judge Allen. Is the
You are
Creole
the only
interpreter available?
participant.
I'm the only participant. Okay. All righty. Why is there so many cases this afternoon? There was hardly none this morning. So did we confirm that I don't have access to these from my system?
Back out, hit the X button.
I go to view calendar, that's how I do it.
Okay, try it again.
It goes directly to this.
Okay, click the calendar again.
In the calendar?
No. Right
Oh, here?
The little orange button.
Yeah,
And
it doesn't have
then
any, that option.
You can't click on just 51.
Yeah, I can click on just 51.
Let's see what happens.
Good morning.
Good morning, this is Judge Allen.
This is Isabel Rocher, the Creole interpreter. Good morning, Judge.
Good morning, Mr. Rocher. All right, Mr. Rocher, let's swear you in, and then we're gonna swear in some other people.
Okay.
Do you solemnly swear to translate from Creole to English, from English to Creole to the best of your ability?
I do. Isabel Rocher, court interpreter, Creole.
Does the victim need? Yes. Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Mr. Rocher?
Yes, ma'am.
And we're gonna swear in the witness.
Okay.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Est-ce que vous sermentez que témoignage soit bail la vérité, toute la vérité, devant bon Dieu?
Oui.
Yes.
Please state your name for the record.
Qui j'en relais?
Fredlin Isaac.
Fredlin Isa.
Oui.
Can you spell your last name for me?
Isaac Fredlin.
Qui j'en écrit signature?
I-S-A-R-C.
ISAAC.
Is it Isaac?
Isaac.
Okay, Miss Isaac.
Good morning, Miss Isaac. Can you please state your relationship to Mr. Amilcar?
Qui s'awouillait pour Monsieur Amilcar?
Madame.
His wife.
Are you afraid of him?
Est-ce que vous peur?
No.
Non.
Has anything like this ever happened before?
Est-ce que bagay ça passé déjà?
No.
Non.
If anything like this or anything more severe ever occurred in the future, would you feel comfortable calling 911?
Si on bagay kon sa t'a privé encore, ou bien on bagay pi sévère t'a privé, est-ce que vous t'a senti ou confortable les 911, 911?
Oui, d'après les, si on va.
Yes, yes, I would call if I need to.
Right. Do you believe drugs or alcohol were involved in this incident?
Est-ce que vous pensez c'est peut-être drogue ou bien peut-être alcool que bagay ça fait, Jean li fait?
Il pas qu'on prend drogue, mais il te goûté alcool simplement.
He doesn't take drugs. He just had some alcohol only.
And do you want to have contact with him while this case is pending?
Est-ce que vous voulez gagner contact ensemble avec lui pendant que Kassa là?
Oui.
Yes.
That's all I have, Your Honor.
All right, remind me, was DCF involved in this case at all?
I did not note it, Your Honor, so I do not believe so.
Ms. Isaac, do you have any minor children? I know you're, according to something I read, you may be pregnant now, but do you have any children?
Madame Isaac, est-ce que vous gagnez Timoun qui n'a qu'à là ensemble avec vous? Il dit peut-être ou enceinte Kounia, mais est-ce que vous gagnez l'autre Timoun qui n'a qu'à là?
Oui, moi j'ai un petit frère qui est avec moi.
I have my brother's child that is with me.
How old is your brother's child?
Qui l'âge Timoun là?
Bientôt 3 ans, 3 ans, 2 ans, maybe.
2 or 3 years old.
Okay, thank you. All right. Any questions?
No questions, Your Honor.
Avocat, pas de question?
Very well. Mr. Ilmokar, sir, I do find probable cause for the charges of aggravated battery on a pregnant person and battery domestic violence.
Dit Monsieur Hamilcar, moi, je que gen assez évidence pour attaque sous un monde qui enceinte et attaque pour une violence domestique.
I am setting a bond of $5,000 as to count 1 and $500 as to count 2.
Moi, mettez un bond de $5,000 pour premier chef accusation et $500 pour deuxième chef accusation.
I am ordering you to have no hostile contact with the victim in this case.
Ou pas capable de mauvais contact avec victime dans cas ça.
I am ordering you to possess no firearms and possess no weapons
Ou pas capable de aucune arme à feu, aucune qualité d'arme.
and surrender any firearms or weapons to law enforcement within 24 hours of your release.
Dit après 24 heures après que vous finissez sorti de prison, ou besoin remettre toutes armes que vous avez gagnées en main, ou tu as besoin de remettre au à la police pour
If-
pour
Oh, sorry, Mr. Rocher, go ahead.
It's okay.
If a DCF order is entered in this case, I am ordering you to comply with it.
Si département Timon avec famille entré dans cas ça, m'a ordonné ou pour suivre ça y a dit.
And I have appointed the public defender to represent you in this case.
Moi bon défenseur public qui pour représenter ou dans cas ça.
Thank you, sir. Thank you, ma'am. I'm
Merci,
sorry,
monsieur.
I'm sorry, the young lady is raising her hand. Ma'am, what did you want to say?
Ça vous voulez dire madame?
Ça m'a voulu dire, c'est parce que moi pas attendre anglais bien. Les policiers ont parlé ensemble avec moi. Li pas tirer coup sur moi, li pas battre moi, c'est li claver tout droit, moi pas don pas capable là. Il pas bon coup, c'est parce que dit la prend téléphone non pour le prendre même parce que me dit m'a envoyer message ba maman pas de la parler parce que elle pas répondre. Quand il a même prend téléphone me fou dans bazar il quitter en bas tête moi ou connaît moi gen bag là non même li passer bon comme li pas bon coup, li pas jamais lever mes sous moi.
It's because I don't speak English very well that I couldn't explain things to the police. He never hit me. He didn't hit me. He did not strike me. It's just I was trying to send a message to my mom, but he was talking to me, so I had put the phone under my pillow, and he tried to reach the phone, but he never hit me. He did not give me any blows.
Well, I did give him a bond, and the bond is $5,000, which is a little higher than what I normally do on a charge like this. If the state has no objection, I'll reduce it to $3,500.
State has no objection, Your Honor. He has no other criminal history.
All right. So, ma'am, since the state has no objection, I'll reduce the bond on count 1 to $3,500.
Puis comme l'État pas gagne aucune objection, m'a réduit bond là au lieu que les $5,000 qu'on y a les $3,500.
And the bond on count 2 will stay at $500.
Et une bond sous deuxième chef accusation a prêté à 500.
All right. Thank you, ma'am. Thank you, sir.
Okay? Merci madame, merci monsieur.
Merci.
Always a pleasure, Mr. Rocher.
Yes ma'am. Bye-bye.
Bye. Can I recess?
You are the only
Court stands in
participant.
recess.
Good afternoon, Your Honor. This is Rafael Barrera, State Certified Court Interpreter. I have been previously sworn.
Very good. Thank you, sir. This is Judge Margaret Schreiber presiding today. I've just called the case of Luis Flores Hernandez, 22 MM 1797. Mr. Flores Hernandez, you're charged with 1 count of battery, unlawful touching, or striking domestic in nature.
Señor Flores Hernández, usted lo acusan de un cargo de agresión, tocar o golpear de manera ilegal con naturaleza doméstica.
I've also appointed the Office of the Public Defender to represent you,
He designado a las oficinas del defensor público para que lo representen.
and I want to make sure you understand you have the right to remain silent, and anything you say can and will be used against you.
Quiero que usted entienda que usted tiene el derecho de guardar silencio y todo lo que usted diga puede ser usado en su contra.
And counsel, you've indicated you have a PC argument. Please make it after the interpreter.
Licenciado, usted me ha indicado que usted tiene un argumento sobre indicios razonables. Por favor, deme su argumento después que termine el intérprete.
Go ahead.
Adelante.
Yes, ma'am. The alleged conduct in question could be categorized as corporal punishment to keep a minor child from illegal activity, as this entire thing, this entire incident revolves around the child in question leaving in a car to drive when he has only a learner's permit.
Su señoría, esta conducta que se alega pudiera ser categorizada como pena corporal, y ya que él estaba tratando de interferir para que el menor no cometiera un delito ilícito, y ya que el menor de edad iba a conducir un vehículo sin tener el permiso adecuado de conducir.
And we'd be asking for him for no PC to be found and for his release on his own recognizance.
Estamos pidiendo que se determine que no existe indicio razonable y que den libertad bajo palabra.
What says the state?
¿Y qué indica la fiscalía?
Judge, nowhere in the four corners of the document, as far as I can tell, does it state the age of the victim.
Su señoría, que yo sepa, en el contenido del documento no indica la edad de la víctima.
So corporal punishment would end at age 18. I don't know whether or not the victim is below 18 for that defense that the state or that the defense is talking about.
Su señoría, los castigos corporales terminan a la edad de 18 años. No creo que el argumento de la defensa puede confirmarse.
Counsel, let me direct your attention to the third paragraph from the bottom.
El licenciado, que por favor revise el párrafo de la parte baja del documento.
Lewis stated called his son Michael to come home due to him driving the vehicle on a learner's license. Lewis stated he knew his son was driving the vehicle without someone with him that was 21 years or older, etc.
Michael llamó a su hijo y le dijo que tenía que regresar porque él estaba consciente que su hijo Luis estaba conduciendo el vehículo y no estaba acompañado de una persona mayor de 21 años de edad.
Does that address that concern?
¿Eso tramita esa inquietud?
No, Your Honor. I understand that to drive with a learner's license, it would require to have someone who's 21 years of age, but it still doesn't state the age of the victim.
No, su señoría, yo entiendo que una licencia de conducir de aprendizaje exige que una persona de 21 años de edad lo acompañe, pero eso no resuelve el hecho de que no indica la edad del menor en el documento.
Response.
Respuesta.
It says in the paragraph directly after that he currently shares joint custody with his wife and they have 50-50 custody of the children. Custody also ends at 18. It is therefore a inference within the four corners of the document that the child is under the age of 18.
Sí, su señoría, en el próximo párrafo indica que él tiene custodia con la ex esposa un 50% del tiempo, ya que la custodia de menores termina a la edad de 18 años de edad. Se puede inferir, basado en lo que indica el documento, de que la persona era menor de 18.
State.
Fiscalía.
I'll just point out, if the victim is under 18, I agree with the defense that there's a sufficient corporal punishment defense. I just don't believe there's enough to find that the victim's under 18 without some affirmative showing of that in the document.
Yo estoy de acuerdo con la defensa que si se puede mostrar que él fuese menos de 18 años de edad, la defensa de castigo corporal sería adecuado, pero no encuentro en el contenido del documento que indique que él es menor de 18 años de edad.
I'm finding there is no probable cause for the charge and releasing Mr. Flores Hernandez, ROR.
Determino que no existen indicios razonables, le voy a dar libertad al señor bajo palabra.
Alfredo, hold on. Counsel, is there anybody else who needs the services of a Spanish interpreter?
I believe so, Your Honor, if there could be a request.
Would the interpreter make the following announcement?
Certainly, Your Honor.
Please raise your hand if you need the services of a Spanish interpreter today.
Si usted necesita los servicios del intérprete en este momento, por favor levante su mano.
Yes, Your Honor, there's one with his hand raised in the back.
Well, let's get a name and call him up.
I believe it is Munez.
Warrant case, new charge, where is he?
Yes, Your Honor, it's a warrant case. It is an added charge, I believe, Munez Bardales. Manuel.
Munez with a M?
Yes, M-U-N-O-Z, B-R-D-A-L-E-S.
I found him.
And my apologies, Your Honor, if you could kindly confirm the spelling of that second last name.
I will. It's Manuel de Jesus Munez, M-U-N-O-Z, Bardales, B-A-R-D-A-L-E-S, 16 CF 1227.
Thank you, Your Honor.
Sir, I've appointed the Office of the Public Defender to represent you.
Caballero designado a las oficinas del defensor público para que lo represente.
You have the right to remain silent. Anything you say can and will be used against you.
Usted tiene el derecho a guardar silencio. Todo lo que usted diga puede ser usado en su contra.
You are here pursuant to an arrest warrant issued for trespass on a posted construction site and grand theft.
Usted se encuentra aquí mediante una orden de arresto por un cargo de presencia ilegal en un sitio de construcción y un cargo de hurto mayor.
The issuing judge set your bonds at, well, the issuing judge already found probable cause, so it's not necessary to find it again.
Bueno, el juez encargado del caso ya determinó que hay indicios razonables, por lo tanto, eso no lo hay que volver a determinar.
Your Honor, I do have a legal argument for his release.
Su señoría, tengo un argumento legal para su libertad.
Go ahead.
Adelante.
There is a statute of limitations on all theft charges of 5 years. This event occurred December 18th, 2015, and the warrant was issued on April 7th, 2016. Both issues would expire in 2020 for the date of the occurrence and 2021 for the date of the warrant.
Su señoría, hay un límite de procesamiento legal de 5 años en estos cargos. Este incidente tomó lugar el 18 de diciembre de 2015, se emitió la orden de arresto el 7 de abril de 2016 y en este caso la fecha límite para el delito sería el año 2020 y la fecha límite para la orden de arresto sería el 2021. Basado en eso estamos pidiendo libertad bajo palabra.
I'm going to deny that request today and leave the bonds as set, $1,000 on count 1, $25,000 on count 2. Make the appropriate motion before the assigned judge.
Voy a denegar ese pedimento en el día de hoy. Voy a dejar las fianzas programadas tal como están. $1,000 en el primer cargo, $25,000 en el segundo cargo. Por favor, entable los pedimentos adecuados en frente del juez del caso. Sí, su señoría.
Was that it for the Spanish interpreter cases? All right. My thanks to the interpreter. Have a nice day.
You as well, Your Honor. Have a good afternoon. Thank you.
Alfredo Augusta. Sir, you're here pursuant to 2 warrants issued for violation of your probation and/or community control. The allegation is that you violated your probation or community control by failing to live without violating any new laws, using intoxicants to excess, and failing to remain confined to your approved residence. In both of those cases, Judge Nix Walker set your bond at 0, no bond where it will remain.
Judge, just for clarification on the record, Mr. Augusta, he was arraigned on these exact counts yesterday. And it's, just so the record is clear, he was arraigned yesterday on this, and he has been in Osceola County for these two cases since July 25th, I believe arrested on the 19th of July in Hillsborough. Yes. And so.
I'm not sure why he was brought back,
Right.
but
I want that to be on record that he was arraigned on this yesterday, and I'm unsure why there's this additional brought forth, because that usually would have been done by an amended affidavit and an additional arraignment before the court that he's already seen yesterday.
was he arraigned on the underlying
On the
new law violation yesterday or on the violation of probation?
violations of probation, Your Honor.
All right.
Your Honor, he has a future court hearing of VOP status on September 29th, 9 a.m.
It's a weird thing that I wanted was on the record.
Thank you. Did you hear the VOP status?
No, Your Honor.
Where's my?
It's just speak.
VOP status hearing September 29th, 9 a.m., courtroom 5A.
Thank you.
Be seated, please. Jean Alonzo Colon. Sir, you're here pursuant to 2 arrest warrants. The first one is for burglary to a conveyance or petty theft. Probable cause was previously found. Your bond will be as set in the warrant, $3,500 on count 1, $150 on count 2. You're also here pursuant to a warrant for armed burglary to a conveyance and grand theft of a firearm. The warrant sets your bond at 0, no bond at this time.
Your Honor, we would ask bond to be set. I believe that he should be entitled to bond at least on the F3.
What says the state?
Judge, I show that the state actually filed on this case and did file an F3, so a burglary of a conveyance and a grand theft of a firearm. The state has no objection to setting a bond in those cases.
Armed burglary to a conveyance, does the state have a recommended bond amount?
Judge, that has been filed on, and it's a burglary of a conveyance now.
Burglary of a conveyance, okay.
And we would just ask for the standard, which I think is 1,000.
All right, then I will amend the bonds as set forth in the warrant. I'm going to set each count at $1,000, $1,000 for the armed burglary to the conveyance and $1,000 for the grand theft of a firearm. I'm going to also order a no return to where this happened. Christina Knowles. All right, you are charged with 5 counts pursuant to a warrant issued by Judge Sandor, trafficking in methamphetamines over 14 grams armed, possession of cannabis with intent to sell, possession of a controlled substance, lorazepam, without a prescription, possession of a firearm by a convicted felon, and possession of drug paraphernalia. I'm leaving the bonds as set in the warrant. $100,000 on count 1, $5,000 on count 2, $1,000 on count 3, $5,000 on count 4, and $500 on count 5. As a condition of your release, you're to possess no weapons or firearms. And you may be seated. Johnny Medina.
Your Honor, we would waive the reading of these
I can't hear you.
Your Honor, we would waive the reading of these charges.
All right. Johnny Medina? VIP?
Yes, ma'am.
Okay. Sir, you're charged with violation of your probation and/or community control. Judge Nix Walker found probable cause and set your bond at 0, no bond. Glenn Mitchell.
Your Honor, the previous defendant has a future court date.
And Judge, was there a court date for Ms.
Yep.
Medina?
We're getting it to you now.
Thank you, ma'am.
In case 20 CF 668, VOP arraignment, August 16th, 9 a.m., courtroom 5A.
Thank you.
Glenn Mitchell. Sir, you're here pursuant to 2 warrants for your arrest. Both are for failure to comply with all instructions given to you by your probation officer, and both set your bond at 0, no bond. Your dates are?
In 20 CF 325 and 20 CF 350, VOP arraignment, August 16th, 9 a.m., courtroom 5A.
Tanya Morales. You're charged with scheme to defraud under $20,000, exploitation of an elderly person under $10,000, theft from a person 65 or older, and criminal use of personal identification information. Probable cause was previously found. Bond is as set in the arrest warrant at $10,000, $5,000, $1,000, and $1,000 respectively. No victim contact, no return to the residence. Malik Sr.
And Your Honor, I do have some information for the court on this one.
Mr. Senior, you're charged with fleeing and eluding law enforcement at a high speed with a disregard of safety to persons and property and reckless driving. Counsel, what information do you have?
Ma'am, the car that was cited within the warrant is actually one that he loans out via Turo, T-U-R-O. He was not the driver at the time. It was rented out at that time.
Loaned out, rented out?
Yes, ma'am. It was loaned out. It was via an app called Turo where individuals can rent their cars to other people.
State?
Judge, probable cause has already been found in this case. It's a warrant. That's a trial defense. And we just ask that the warrant remain as it is.
I agree. Raise that at trial or raise it with a request to lower bond or dismiss the charges.
And these, we would just be asking for bond to be set.
I will. Bond is set at count 1 at $2,500 with PTR. Bond is set at count 2 at $100.
And Your Honor, he does qualify for direct PTR. We would be asking for him to be released direct PTR.
I'm not doing direct PTR on a fleeing and elude under the facts of this case.
Thank you, ma'am.
Dash Vincent. Sir, you are here pursuant to a bench warrant issued for your failure to appear for your arraignment before Judge Sanders Morency. She issued the warrant, found probable cause, but gave you a bond amount of $2,000.
Your Honor, for this particular client today, Mr. Vincent, the address of 2425 Frontage Road, Davenport, is not the correct address. He had no notice of the court date, and we would ask if bond could be lowered.
I am going to ask that you address that before the presiding judge, or the assigned judge. Thank you.
Your Honor, he has a future court date. If he is in jail August 18th, 8:05 a.m., courtroom 5B. If bonds out September 1st, 8:15 a.m., courtroom 4A.
Samuel Gonzalez. So why is only one of these? What's this one? That's the original charge.
That's the count that they're.
I don't understand what this is. Undue violation of probation.
This is the paperwork that came with the booking report, and I handed it to my supervisor, and she put this out to provide to you. Okay.
Sir, you're here pursuant to an on-view violation of your probation as to count 2, resisting merchandise recovery. State, I guess he picked up a new charge or violated the probation, but only as to count 2.
It appears count 1 was null prost.
Okay. All right. What conditions of release is the state asking for? VOPs, I typically do a no bond.
Your Honor, I see that they did docket additional information. I'm printing it out for you in case you want to review that. It's an affidavit of violation of probation, and it seems that the count is different than what I was provided. There are 2 more pages.
Can you quiet them down in the hallway, please?
Judge, the state would be asking that it stay at a no bond status. The violation were of condition 5, so it is new law offenses, and they include resisting and assault on a law enforcement officer.
And I have been provided a copy of the affidavit of violation of probation that goes with this case. Apparently, it was dated yesterday. I'm going to set bond right now at 0, no bond for the VOP.
And, Your Honor, I believe that was for...
Can't hear you.
Apologies, Your Honor. I believe that was for the 3 cases. It should have been 22 MM 527, 22 CF 688, and 22 CF 723.
Yes.
Your Honor, we were only provided paperwork for 22 CF 688.
There's 3 case numbers on this, so I'm going to do it as to all 3.
Okay, the orders were not prepared for those due to the information that was given this morning. That affidavit was filed after the court paperwork was taken upstairs. But I can create those orders now.
Go ahead and create the orders because I don't want to have to drag them back here tomorrow, so.
All counts at 0.
Thank you.
Thank you, Judge.
Larry Rhodes.
Your Honor, we would waive his appearance and we would waive the reading of the charges.
Judge, may I be heard on this case?
Do you have a motion?
There's no motion, Your Honor. Information was filed in this case. It is showing on the clerk's site at this time, so I just wanted to bring that to Your Honor's attention and make sure it's several cases being consolidated, so I wanted to make sure that we went through each count on what the bond is on those counts.
Okay. Give me a case number, counsel.
22 CF 1914.
Five counts?
8 counts.
8 counts.
I think it's 5 pages.
Got it. Well, are we arraigning him on that or what I have before me? You've direct filed.
So, Judge, he's on the information as to count 3. He's already been IA'd on that case. There's been a pretrial detention motion, which Judge Karsten granted.
Okay.
On counts 4 through 8, he's already been IA'd on those counts, and the judge set the bond on those counts at $5,000. He's never been arrested on count 2, and he is entitled to a bond on that count. And on count 1, we're asking for a no bond status.
All right.
And Your Honor, I would just ask for the arraignment to be set in front of the trial court. Defense has not been provided with the information at this time.
A little bit louder, counsel. You keep getting away from the mic.
I'm so sorry. We would ask for the arraignment piece to be set in front of the trial judge. I have not been provided the information. I only had the additional charge. And so we would ask for that to just be set in front of the trial judge.
So you want him only arraigned on the warrant before the court today, when the state has already filed?
Your Honor, we would ask for just the arraignment itself to be set. If there was a bond that needs to be set, we would ask for that to be set. But the actual arraignment, I would ask to be in front of the trial court. I had no information that that would be occurring today.
Well,
We just had the additional charge, Your Honor.
state?
The state has no problem with that, Judge. That would be just doing an initial appearance on count 1. The issue is that we'd have to bring him back for count 2 because he's never been arrested on that case. So there would be an initial appearance on that in the coming days.
And count 2, he gets a bond on.
Your Honor, we would just ask for a bond to be set on count 2 today, and we would ask for the arraignment to be set in front of the court, the trial court.
No, I'm not going to do that. I'm going to arraign him on count 1, or do his IA on count 1. So we have 3 different charges. One is what's in the affidavit. He needs to have his initial appearance on that. But the state is not charging that. They're charging, and it's hard because we can't talk about what the charges are, but they're charging what has now been charged as count 1.
That's correct.
And then count 2 he's not been arrested on?
No, Your Honor.
And counsel, you do not want him to have an IA on count 2 since he hasn't been arrested on it?
Your Honor, if a bond needs to be set, it can be addressed at the arraignment.
I can't hear you.
If a bond needs to be set, it can be addressed at the arraignment. As I have no knowledge of count 2, we would never informed of count 2. I only have what is in the paperwork for today.
Me as well. I only have that.
So nobody knows about the filing?
It was filed 30 minutes before I came up here, Judge.
All right, I'm going to go forward on the paperwork I have, and then the paperwork I have is the charge, the single charge. Probable cause was previously found, and bond will be set at 0, no bond on that charge.
Yes, ma'am.
William Asensio. Sir, you are here for 2 cases. Grand theft in an amount greater than $300 but less than $5,000, and burglary of an unoccupied structure unarmed. I find probable cause for those charges. Bond is set at $2,500 on count 1, $150 on count 2, with the additional requirement that you are not to return, to the location where this occurred. In the other case, you have 2 counts of possession of a controlled substance without a prescription, and 1 count of possession or use of drug paraphernalia. Bond is set on count 1 at, those all qualify for direct PTR, is that right?
Yes, ma'am.
All right, so on those 3 counts, it'll be direct PTR.
Case 2, all 3 counts PTR, correct?
Yes.
And if you made the first case, count 2, what is the bond again?
$150.
And Your Honor, for
Grand theft, $2,500. Unoccupied structure, $150. All the drug charges, ROR, or direct PTR rather, not ROR, direct PTR.
Judge, for the drug charges, did you make a PC finding?
Yes, PC, I'm making a PC finding as to all charges. Cesar Batalis.
Your Honor, just to speak about Mr. Asinio quickly, could we please have a $100 bond on each count for those?
On the, all 5 of them, or just
On the drug charges, Your Honor.
as opposed to?
The direct PTR, he can't bond out, and to direct PTR him on only the drug charges would prevent him from getting the time which he is going to be receiving on the other case.
Any objection?
No objection, Judge.
Okay. I'll modify that on the 3 drug charges per request of the defense. Bond is $100 per count in lieu of direct PTR. Cesar Batalis?
Your Honor, corrections have asked me that he'll be brought after for mental health reasons, Your Honor.
Okay, so we'll call him later.
Thank you.
Juana Benetic? You are charged with grand theft in the amount greater than $750 but less than $5,000. I find probable cause for the charges. Pursuant to the administrative order, I'm releasing you under direct PTR conditions with the additional condition that you not return to the Walmart located at 2855 North Old Lake Wilson Road. Angelina Izquierdo. You are charged with trespass. I've reviewed the charging affidavit. I find probable cause for the charge. You're released under direct PTR conditions pursuant to the administrative order with the additional stipulation that you not return to the mobile gas station where this occurred. Jessica Lavera. You're charged with grand theft in an amount greater than $300 but less than $5,000. I've reviewed the charging affidavit. I find probable cause for the charge. Pursuant to the administrative order, you're released under direct PTR conditions with the additional requirement that you not return to the Walmart store located at 2855 North Old Lake Wilson in Kissimmee. Nautica Lavera. You're charged with grand theft in an amount greater than $300 but less than $5,000. I do find probable cause for the charge. You're released under direct PTR conditions pursuant to the administrative order. No return to the Walmart location in this matter. Michael Lucky.
That's okay.
You are charged with DUI, driving under the influence of alcohol or drugs, and refusing to submit to a DUI test after license suspension. I've reviewed the charging affidavit. I do find probable cause for the charges. Bond is set at, you qualify for direct PTR, so I'll release you under direct PTR conditions.
Judge,
With, yes.
the
Yes.
state's asking for a monetary bond in this case, Judge. The defendant does have two prior convictions for driving under the influence that are listed in the charging affidavit. That's all from the state.
And Your Honor, defense would continue to ask for direct PTR per the admin rule.
They're pretty old, so in this case, I'm going to decline the state's request and release them under direct PTR, 2004 and 2007. All right. Vilma Melendez. You're charged with one count of battery, domestic in nature. I reviewed the charging affidavit. I do find probable cause for the charge. PTR, have you had any contact with the alleged victim?
No, ma'am. We was provided the wrong phone number.
So, all right. Bond is set at $500 with PTR conditions. No contact. Maintain separate residences. Possess no weapons or firearms. $500 with PTR, no contact, no weapons or firearms, and maintain separate residences. Roman Towns. Sir, you're charged with one count of battery, simple touching or striking, domestic in nature. I do find probable cause for the charge. PTR, still no contact with the alleged victim?
No, ma'am.
Then bond is set at $500 with PTR conditions. No contact with the alleged victim, maintain separate residences. No weapons or firearms. If you reside together, one-time return in the presence of law enforcement to gather your personal possessions. Ian Yankee. Sir, you're charged with one count of battery, unlawful touching or striking. It is not domestic in nature. I've reviewed the charging affidavit. I find probable cause for the charge. Bond is set at, well, conditions are set. I'm going to release you under direct PTR. Jarrell Hurley.
Judge, I'm sorry, in the Yankee case, with direct PTR, can we just get a no contact order as well?
And a no contact order. For the one I just called, Ian Yankee.
Okay, yes, ma'am.
I don't have a cover sheet for the next one from PTR. Initial appearance information sheet on this one.
Early?
For Hurley, correct. I do look at them, thank you. All right, Mr. Hurley. Well, my question is, does he qualify for PTR? Because it's not circled on anything.
That's right, he's, currently incarcerated.
I don't have that on here either. I don't have any of that information. So, let's just do this. Mr. Hurley, you're charged with possession of a controlled substance without a prescription and possession and or use of drug paraphernalia. I've reviewed the charging affidavit. I do find probable cause for the charge. Let me hear from PTR regarding bond and prior history and eligibility for direct PTR.
You know, we would just be asking for bond in this case, not PTR.
That's fine. Bond is set at $2,500 on count one, $500 on count two. And that is all.
I believe that we have
We have two more.
yes, ma'am.
Do we have Caesar Batalis yet, or do we want to go with
He's on his way, Your Honor.
Nash?
And we'll go with Nash.
All right.
And, I know this is a reset from yesterday. Defense was not provided with any additional information, and so we would adopt the, same arguments as yesterday. And ask
Well-
that no,
Before you go too much further, I've just been handed the information.
filing of the information?
Yes,
Was this one also done 30 minutes before court?
I don't know, but they gave it to me at IA's, so I'm going to go with it. Let me hear from the state.
Judge, the state did file this information. We were able to get enough information to do that, and the goal was to fix the issues with that home invasion that I understand was a PC argument yesterday. I agree there was no PC for that, but there are two charges, charges 5 and 6 for burglary of a dwelling with a firearm, with an assault or battery therein.
I didn't. Counts 1 and 2. I don't think he was charged with yesterday. Is it all new?
So, Judge, counts 1 and 2 would be the last two counts there.
Criminal
Attempt to
attempt.
commit a life
7774.
felony.
Okay. So
And
those were the
then-
high bonds I gave yesterday.
Yes, Judge.
What about attempted felony murder?
Those were not charged, Judge.
Okay.
And then the burglary of a dwelling, like I said, was not charged. They're all life felonies, and the state would be seeking no bond and seeking to move forward on an Arthur hearing
All right.
if necessary.
All right. So let me start with yesterday. This was reset because the court found no PC on the 3 counts of home invasion with a weapon. Yesterday, it was the home invasion with the robbery, gave them 24 hours to reset. The state has acknowledged there is no PC for those charges, so those charges, I find no PC, and would release her ROR to the extent required. With regard to the new charges, attempted felony murder, 2 counts, and of a dwelling with an assault or a battery, 2 counts. The state has direct filed, and I'm setting bond on all of those at 0. So she's got a bond of $250,000 on counts 1 and 2 each, and no bond on 3 through 6.
Okay. Thank you, Your Honor.
I did that yesterday. It's not new.
And
It was $250 per count, not
yes,
1,
the last two.
from yesterday. All right. Is there any other, did I include a no contact order yesterday?
Yes.
So let me add the no contact order as well for the new counts.
And they've already taken her out, Your Honor.
All right, that's fine. Yesterday, I ordered no contact and do not return. I just want that to go to all counts.
Okay. I need her. She's right here, Your Honor. It's just another moment.
Do we need to get her back, or will you relay that?
She's right here. On the new counts, they issued no contact, no return. Okay? She's been informed, Your Honor.
Thank you. And Cesar Batalis.
Yes, and Your Honor, I have some argument in regards to him being released.
All right. Sir, you are charged with trespass on property, not a structure or conveyance. So you don't have a PC argument, you have the other argument, correct?
Yes.
All right, I do find probable cause for the charge. Go ahead, counsel.
Your Honor, he's been most recently found incompetent to proceed in 21 MM 2083. The last evaluation conducted, and I do realize it's stale, was Dr. Tate on January 28th, 2022. He was found incompetent to proceed due to his schizophrenia diagnosis, and that case was dismissed on May 9th, 2022. Per the rules and per, one moment. Per Blow v. State 902 Southern 2nd 340 from 2005 out of the 5th DCA, we'd be asking for him to be released as there's been no subsequent finding of competence, and there's been no subsequent finding of competence, and incompetence remains presumptive until competence is determined.
Any objection by the state?
Judge, the state would be seeking that he be released on mental health PTR if he qualifies for that.
Don't qualify.
And Judge, the state's just asking that there be a no return order, by Your Honor.
Response to the request by the state.
Your Honor, we would just be asking for him to be released. If he qualifies for mental health PTR, that's fine. If he doesn't qualify, we would be asking for his release as I stated, he is still incompetent to proceed, and we would not wish for him to further deteriorate while in custody.
I'm going to release some ROR with the additional stipulation that he is not to return to this location, the 7-Eleven located at 800 Cypress Parkway. Go back to that 7-Eleven, go back to jail. That's how it's going to work. And in fact, I'm going to expand that to include all 7-Elevens. So you may not return to any 7-Eleven. If you do, you will be arrested. All right? Thank you. Does that empty the room, council?
Yes, ma'am, that was
All right, we are adjourned. Thank you.
Thank you, Judge.